Okay, great. We are streaming now. So we'll begin again with committee introductions. Senator Hickman.
Good morning, everyone. I'm Craig Hickman. I represent Senate District 14, 11 towns in Southern Kennebec County.
Okay, House Chairman Chiazzo.
Thank you, Mr. Chair. Good morning, everybody. Chris Chiazzo, House District 28, beautiful West Scarborough.
Okay, Representative Supika.
Good morning, I'm Laura Supika and I represent District 126, the most beautiful portion of Bangor.
Representative Riley.
Hi, I'm Representative Morgan Riley. I represent House District 34, which is part of Westbrook.
Okay, Representative McCray.
Good morning, everybody. I'm Jay McCray. I represent Harpswell, West Bath, and Northeast Brunswick in the House, and it's nice and sunny here today, no fog.
Representative Wood.
Good morning, I'm Barb Wood, and I represent House District 38, where it is also very sunny this morning and casting shadows over my face. I am in the Western Peninsula of Portland.
Great, thanks. And with us today, we have our OPLA analyst, Sam Prower, and we have our committee clerk, Karen Montel. Okay, so before we get, let's give it a second. And we have with us today Representative Kinney, if you'd like to introduce yourself.
Sure. Good morning. Thank you, Mr. Chair. Mary Ann Kinney. I represent House District 99 in West.
Great. So to begin, we'll share just a few pieces of information regarding the procedures for our electronic committee meetings. The meeting is, so everybody knows, the meeting is currently being live streamed on YouTube. The audio is also being live streamed through the legislature's website. Just a reminder that anybody who is a participant in the Zoom meeting can be seen and heard if their microphone is on and unmuted. People in the list waiting to testify on the bill can't be seen or heard until we pull you into the meeting as panelists. And just a note that we always make is that it may seem like you're being dropped for a couple of seconds when you're being brought in, but if you just wait a second, you'll pop into the meeting. Anybody who submitted written testimony, it will be publicly posted on the legislature's website. Regarding the chat function of the Zoom meeting, this is for technical assistance only. It's not for substantive committee work. And as I mentioned earlier, we're going to group our bills into two sections today. So we're going to begin with feedback. Okay. So we're going to have the first group of the three department bills from OMP, which is 881, 882, and 1029. And then after that hearing is done, we'll go to the second grouping, which is 525, 605, 613, and 939. So if anybody has pre-registered on any of those bills in each grouping, so any of the first three, we'll make sure that you're called upon to speak. Just a reminder for those members of the public, when you're called upon, please state your name, your place of residence, and the organization you represent, if any. Only remarks on the legislation before us are considered in order. Any remarks otherwise are considered out of order. And a reminder that testimony is limited to 3 minutes in duration for each block. So please tailor your remarks accordingly. Okay, so with that, we will open up the first block of public hearings. So I'll turn it over to the House Chairman, as these are all three department bills where I am the introducer. So,
Thank you, Mr. Chair. The chair will recognize Senator Lucchini for introductions of his bills.
Thank you, Chairman Chiazzo. Yeah, thank you, Chairman Chiazzo, members of the Veterans Legal Affairs Committee. My name is Louis Lucchini. I represent most of Hancock County in the Senate. I think I actually forgot to introduce myself earlier, so that's good. And I'm here to introduce three bills on behalf of the department, which I'll briefly introduce each one, and then the the director of OMP can elaborate on why they're moving it forward. So the first one is LD 881, an act to make technical changes to the Maine Medical Use of Marijuana Act. As outlined in the summary, it makes changes to the definition of immature marijuana plant, and seedling. And it also requires a registered caregiver operating a caregiver retail store to acquire a separate registration certificate. The next bill is LD 882, which is an act to amend the Maine Medical Use of Marijuana Act. And again, if you look in the summary, this does a few things, which allows the OMP to place a hold on marijuana plants and harvested marijuana, to permanently revoke registration ID cards and registration certificates issued by the department, and to assess fines for misconduct by a registered caregiver retail store, dispensary, manufacturing facility, or person authorized to engage in marijuana extraction. And finally, we have LD 1029, which is an act to amend the Marijuana Legalization Act and the laws governing the taxation of marijuana. And again, this does a few different things, but it requires cultivation facilities, licensees to remit excise taxes on transfers of marijuana flower and marijuana trim received from registered caregiver or registered dispensary. And it also permits permits an adult use cultivation facility to accept from registered caregivers and dispensaries unlimited transfers of marijuana plants, marijuana flower and trim years after the date the department DAFs issues its first active facility license. So those are the three bills in this first block. With that, I'll attempt to answer any questions. Otherwise, we can turn it over to the director.
Thank you, Senator Lucchini. Any questions from the committee for the senator regarding LD 881, LD 882, or 1029? Okay, seeing none, we will bring in Director Gunderson, and then we will proceed to those in favor. Let me grab, there he is. Okay, excellent. Director Gunderson, when you're ready.
Great. Thank you, everybody. Good morning. And there's three bills here, so I'll try to move quickly to be respectful of everybody's time. Good morning, Senator Lucchini, Chairman Chiazzo, and members of the VLA committee. My name is Eric Gunderson. I'm Director of Office of Marijuana Policy.
Director Gunderson, I think we've lost your video, or your audio, excuse me.
Yeah, Director. I think he may have lost our audio as well.
Yeah.
Oh.
Sorry, am I back?
You are back now. Yeah.
Yeah.
Sorry about that. So the first bill we're putting forward to address some technical issues that we've identified over the last year and a half. And this, again, is 881. First, the bill, we're cleaning up some definitions. First, we remove seeds from the definition of marijuana plant. It clarifies the definition of immature marijuana plant and reduces the size of seedlings from 24 inches by 24 inches to 18 inches by 18 inches. It's a similar proposal that we brought forward last year, really just an effort to help align some of the definitions within the two cannabis programs we regulate. And you'll see this change mirrored in another department bill. Currently on the adult use side, they're defined as 6 by 6. In the medical program, they're 24 by 24. And since they're two cannabis programs really based around the same plant, we're looking for some consistency in definitions, which would help with the work that we do. There was some concern about moving it from 24 to 12 last session. And we heard those concerns. And during that process, 18 inches was thrown out as a compromise. So we're moving forward with an 18-inch definition there. Next, we're proposing registration fees for caregivers that want to register by canopy, which was an option that the legislature moved forward with. However, at that time, they failed to move forward with a a fee schedule for the canopy base for those wishing to register by canopy base. So we were put in the position where we would either not offer that as an option or offer that as an option by the fee schedule that we already had in statute, which I'm pretty sure was not the intentions of the legislature. We ended up moving forward with it. So we have registrants that are paying that registration fee by the plant count registration fee. And again, I think the intent was to have a flat fee for those registration types. So we're clearing that up, hopefully, with a flat registration fee for canopy, which is $1,500. And then finally, there are provisions in the bill regarding the implementation of a separate registration for those caregivers wishing to operate retail stores. Those provisions were included in error. We had that in there as a way to marry the requirement that those wishing to have a store need local authorization, but working through the regulations and working through our licensing system, it's actually not needed. So if the committee would consider removing that, that would be much appreciated. I'm going to skip over to the next bill, 882. This one was similar to one that was brought forward last session to the Health and Human Services Committee. And through that process, they asked us to form a working group of industry stakeholders to have conversations about some of the provisions in this bill. Simply, we're asking for additional administrative tools to help ensure compliance within the program. Right now, the only administrative tools that the department has are revocation and suspension. And to approach this with a more progressive administrative process to help ensure compliance, we think these additional tools are necessary, much like the other cannabis program, which we regulate the adult use. So first, OMP is looking for what we call administrative holds, which allows us to temporarily put a hold on product as it moves through the system. And really, this tool is tied to the state's inventory tracking system, which has not been implemented in the medical program yet. But it's there for a couple different reasons, most primarily public health concerns. So really what happens is we're allowed to place an administrative hold on product as it moves through the system for a number of different scenarios. And it's only limited to 30 days, which would give the department time to investigate complaints or concerns that are brought to our attention. First and foremost, I said from the public health perspective, if and when we receive complaints about potential contamination or negative health impacts of products, the Office of Marijuana Policy can put an administrative hold on those products to ensure that they don't continue to end up in the hands of patients, giving us time to investigate to see if there is actual contamination, which results in a negative health outcome. And that's also an important piece when you marry it with the inventory tracking system, because if it does indeed pose a public health threat, through the inventory tracking system, we're able to track source packages back to all of those products, which is important with wholesaling because it could be on store shelves across the state, which we think is an important tool. Next, it would allow OMP to permanently revocate individuals for the most egregious misconduct. During the stakeholder group, there was broad consensus around this, and we think it's a necessary tool as of right now. If we were to revocate a registrant, no matter how egregious the act, they are allowed to reapply a year later and come back into the system. And then finally, the bill would authorize the Office of Marijuana Policy to assess fines for noncompliance. Again, looking for that approach of a more progressive way of ensuring compliance, not just revocation. This was the one that had the most spirited debate in the stakeholder group. There was a sense of agreement that OMP should have the ability to fine. The conversation was really about the fine levels, and we absolutely heard that as far as appropriate to scale for the medical program and the registrants. To that end, we're moving forward with a fine schedule that's 1/10 of what it is in the adult use, and really a two-tiered system. So for dispensaries and caregivers operating caregiver storefronts, really the more commercial end, fees are up to $10,000. And then for those registrants, those smaller home-based caregivers per se, a fine schedule that goes up to $2,000. And within those fine schedules, there are 3 tiers. major penalty affecting public health, a major penalty, and just a penalty. And we have really fleshed out what those different tiers look like, and we're happy to share those with the committee. And then moving on to the last bill, again, trying to be respectful of your time here. 1029 would permit the transfer of marijuana flower and trim from the medical program to the adult use program. This one had broad agreement that it would be good for the program. However, when we brought it forward, it was before the launch of the adult use program, and there was concerns about product within that system. We have since launched, but we still think that it could have benefits for the adult use side as summer rolls around, and we have heard from the medical side that they are interested in selling flower and trim into the adult use system. Currently, it's just allowed to transfer plants and seeds. So this is opening the door to include flower and trim. I think if the committee wants to consider this, the one thing I would pay particular attention to is the way the bill that was drafted last session, and we left it in this bill again because there was consensus, was for the unlimited transfer of flower and trim. The other consideration would be to leave it where it is now with the one time, and then to incorporate the flower and trim as well. Just something for the committee to think through and hear testimony from others. But since, again, there was broad consensus, we wanted to bring it forward again. And those are the three department bills.
Thank you, Director Gunderson. Any questions for the director? Representative McCray.
Thank you, Mr. Chair. I lost you as you were talking. When you were talking about 882 and the two tiers, you said it would be 1/10 of that. What's the rest of that sentence?
Oh, it's 1/10 of the fine schedule for the adult use program. In the adult use program, they have the same fine schedule and tiers. For the major violations affecting public health and safety, the major violations and the minor violations. However, on the adult use side, the legislature had a max fine of up to $100,000. And so for an attempt to right size the fine schedule and receiving that feedback from the stakeholder group, we've set it at 10,000.
Thank you.
You're welcome.
Senator Hickman.
Thank you, Mr. Chair. Thank you, Director, for your testimony. Can you tell me, since the commercialization of the medical marijuana program, what kinds of compliance challenges have you seen? Have you gotten any complaints about product contaminated that would negatively affect the public health? And what action have you taken regarding those complaints?
Well, so for specific complaints, I'll say as of last year, as of last year, the state implemented its first ever inspection program. Before that, the program had its registrants and two field investigators, so it was very complaint driven. Now we actually have a proactive inspection program in which we schedule and work with our registrants. However, last year, OMP conducted just under 1,300 inspections and received just under 200 complaints. And that's from a wide array of individuals, whether it be towns, other registrants, patients, and whatnot. I mean, as far as specifics, I can give you some. I'd also be happy to bring our Director of Compliance to give you more specific details as far as what we're seeing in the field. But I can speak to some recent ones that we've gotten from individuals who bought product that hadn't made them sick up in the Bangor area. As far as what we did there, we visited that registrant and they were very happy to comply with us. They gave us some of the product that was sold to the patient that made them sick, and we brought it to one of the testing facilities in Southern Maine to have it tested for potential contaminants. And we did that, and we were not able to substantiate any of the complaints that that individual had about the product. So that's one example. Recently, we have intercepted, I guess is a term I can use for lack of coming up with a better one, with the help of another registrant, nearly 50 pounds of marijuana flower that was tested positive for Eagle 20, a prohibited and dangerous pesticide when smoked or consumed in any way. So, I mean, there's a number of different things that we would see or hear from patients or registrants or others that would warrant this ability to have this tool in place.
Do you keep track? I'm sorry, Mr. Chair, may I have one follow-up?
No, please, go ahead. Go ahead.
Thank you. And do you keep track of these complaints, and what percentage of the complaints that you keep track of actually results in action by the department against the complainant?
Yeah, so we do keep tracks. We do keep tracks of the complaints. As I can say, we have it here: 186 complaints from 2020. And as of right now, the tools that we have in order to help alleviate some of the issues that we do have are lacking at this point. Some of the main complaints that we hear, not having to do with public health. Senator Hickman, are you asking specifically about potential public health complaints?
I'm asking specifically about that, and how does the department currently work with the Board of Pesticide Control on any complaints stemming from prohibited pesticides on plant products?
Well, as of right now, like I said, the process that we used with that last pesticide complaint was simply to work with the registrant, get some of that, get the certificate of analysis from the testing facility in which they did use, and verify both from I believe it's the state toxicologists, DHHS, and the Board of Pesticides to make sure that what we're seeing is real and making sure that the amount that in it poses a threat to public health. But again, in the medical program, pesticides, certainly Eagle 20, are outright prohibited. So it's really more of a conversation about compliance with that rule, as well as the fact that that requirement is there to help protect public and patient health.
Okay, I'll probably ask some more questions for the work session. Thank you.
Yep.
Senator Hickman, did you want us to ask the department's compliance officer to be available for that hearing as well, or are you content with the answers that you're getting from Director Gunderson?
I would like to hear from the compliance officer. Thank you, Mr. Chair.
Any other questions for Director Gunderson? Okay, seeing none, I will turn the gavel back over to Senator Lucchini.
Thank you, everybody.
Great. Thank you, Mr. Chair. So where we've merged three bills, so anybody who had signed up to testify on any of the three bills, we have kind of merged into a list, and people were, for some, against some. So we're just going to go through the list of names as we have them, regardless of position, because it could be different. And feel free to speak about any one or all three bills that you'd like. And a reminder again that the testimony is limited to 3 minutes, and try to keep your comments to the bills before us. So we'll begin with Amber Patterson, followed by Arlie Kraus and Asher Putterman. I'm not seeing Amber at the moment in the list. If you are in there, Amber, if you can raise your hand, that would be great. Otherwise, let's go ahead to Arlie Kraus. Welcome.
Can you see me and hear me okay?
Yep.
Oh, great. Okay.
Great, welcome.
Hello, and thank you for having me. I'm here to testify in opposition to LD 881 and 882. Ought not to pass. Senator Lucchini, Representative Chiazzo, and members of the Committee on Veterans and Legal Affairs. My name is Arlie Kraus. I'm a registered cannabis caregiver, farmer, and business owner in Warren. I'm a founding member of the Maine Craft Cannabis Association. I'm a member of Seed to Health, Learning Health Alliance, and I am the chair of the Adult and Medical Marijuana Committee for the town of Warren. I'm testifying today in opposition to 881 and 882. LD 881 has been written to prevent a caregiver from having a retail store unless applying with a new license type, and to further limit the size of an immature marijuana plant by several inches. I do recognize that Administrator Gunderson has taken this off the table, but I'm still going to just briefly speak to it, just because it's very pertinent to anyone with a small business such as myself. While these have been pitched as innocuous housekeeping changes, they are far from that. Taking away one's right to have a retail space to sell the goods they produce and provide to their patients cannot be viewed as anything other than deliberately ending the livelihood of Maine caregivers of the medical marijuana program and access of the citizens of Maine to their medicine. Where is the justification for such a move? I ask you to question this motive. Maine is the most rural state in the United States, and approximately 61% of the population resides in a rural area. Preventing marijuana farmers such as myself from continuing to grow businesses by nonsensical new rules, which would put more cost on our business with new permits for fabricated and flat out made up reasons, is outrageous. Reducing the size of an immature plant by several inches is also impeding the ability of a cannabis farmer to do their job. I can give you a parallel example of agriculture food production farmers having restrictions on the size of immature tomato plants or heads of lettuce. Does this happen? No. Has there been any input from marijuana farmers in Maine about this rule? No. Where is the input coming from to change the rules which have worked very well for over 20 years? Cannabis public policy consultants and Andrew Friedman. Andrew Friedman, who is also partnered with Big Tobacco, Big Alcohol, and Big Money, is at the tip of the pen writing our new and quote unquote safer rules for Maine. So safe, in fact, that Mr. Friedman, together with Philip Morris, Molson, Anheuser-Busch, and you can probably guess at this point all of the other names involved, has started a federal policy group to keep us all safe from marijuana while they lobby for control of the whole pie. Like with the dairy farms, which created independence and industry for this state and so many others, the corporations know how to crush and capture. They are doing it right here in real time. LD 882, punishing business owners with fines and sentences which do not match the offense by way of being massively unreasonable,
Ms.
is a
Crouch,
tactic only.
your time has expired. If you can wrap it up very, very quickly in 10 seconds, we'll allow you to.
Okay.
Yeah.
Yes, I will. And I will submit my written testimony for you to read. I'll just do my closing statement. In no way are we in the medical marijuana industry implying a system without repercussions for willfully breaking laws is the right one. But what should stay in place is the ability to fix mistakes and stay in business without the threat of perhaps multi-generational obliteration. I request that the punishment fits the crime and not the other way around. I ask you to oppose both LD 881 and 882 today. And I just wanted to mention one other fact. I believe that the Board of Pesticide Control should be included in the work session if it has anything to do with testing of products. I know that they have not been invited to the table, and I think that is a very pertinent industry to be included in discussions.
Thank you for your testimony. Any questions from the committee at this time? Seeing none, thank you for your testimony today.
Thank you.
Okay, so I do see Amber, but we'll go Asher Putterman first, and then we'll go Amber Patterson, followed by Alicia Melnick.
Hi, everyone. Thank you for your time and service to our state. My name is Asher Putterman. I'm a patient and caregiver in Warren. In addition to this, my wife and I operate a commercial cut flower and vegetable farm using organic practices. I stand in opposition to this bill. I see this legislation as taking us backwards. Limiting the size of non-flowering seedling plants from 24 inches down to 18 inches will make breeding and sexing plants much more difficult, as we often have to grow plants out to about 5 weeks before their calyxes will show if they are male or female plants. Obviously, unless we are using them to breed and make more seeds, we have little to no use for male plants when growing sensimelia or flowerless, seedless flower that the market is currently looking for. We already struggle with many challenges growing in Maine. For us, this requires searching through large amounts of seedlings in order to find disease-resistant and desirable cultivars to bring to market. In our experience, running through numerous seeds over many years, most seedlings will not show whether they are male or female until about 20+ inches in height. This has been brought up in previous sessions with the legislature, and the seedling height was set at 24 inches because of that. This is an attempt by the department again to overburden small-scale cultivators by using technicalities to hamstring our cultivation, therefore preventing our businesses from being able to compete in the market. If the department wishes to develop more stringent technical rules for cultivation, they should at least have a basic understanding of a wide variety of cannabis cultivation techniques, which they have proven time and again that they do not. They base their decisions off the largest scale cultivators who are using only clonal propagation and who are trying not to innovate and breed plants to bring unique cultivars to market based on patient needs and instead make money. These larger cultivators are also growing almost entirely indoors, which means they do not have to breed for disease resistance. We flower all of our plants under the sun. We use far less of Maine's resources and are far less of a burden on Maine's power grid than these larger commercial grows. We should be supported and encouraged, but instead our cultivation styles are constantly attacked by the department and their backwards rule changes. I also had a bit of testimony about the part that Director Gunderson asked to be removed, and I just agree with that the caregiver store part should be removed as well.
Great, thank you, Mr. Putterman. Any questions from the committee at this time? Representative Wood. Yeah.
Thank you, Mr. Chair.
Yeah, I got you.
Mr. Putterman, the very last thing you said, I didn't quite catch about the caregiver retail stores. Could you just?
Oh, there was a section in there that removed a caregiver's statutory right to operate a caregiver store. And I could go ahead and read what I had written down. It removes the caregiver's statutory right to operate a retail store when at the same time the department was not even able to tell me the difference between a caregiver store and a caregiver office when I asked the question during testimony on the proposed rules. Nobody within the department was able to answer that. Why are we making more roadblocks to having a business while at the same time requiring us to retail 25% of our sales? And they can't even clarify like their current rules. They're just adding more layers of rules that will prevent us from doing business that we're required to do. We'd happily just wholesale, but we're not allowed to wholesale. So as our wholesale business grows, we're required to retail more. The only way to do that would be through a retail store, but then they're blocking us from having a retail store. It's almost like they're just trying to stop us from existing.
Okay, so currently you are allowed to have a retail store and the new rules are trying to remove that.
Yes, and I believe Director Gunderson realized that and removed that. So I recognize that and I agree with that.
Okay, thank you.
Thank you.
Great. Any other questions from members of the committee at this time? Seeing none, thank you, Mr. Putterman.
Thank you all for your time on this.
Thank you. Okay, so it looks like we have Amber Patterson in the room. It appears Alicia Melnick has left, so we will move after that to Catherine Lewis. So, oh, there we go. Yeah, we can see you.
Hi, good morning.
Welcome.
Welcome. My name is Amber Patterson. I'm out of Kennebec County. I am a caregiver in Fayette, and I'm also an assistant at the Honeycomb Farm in Wilson. I'm before you today to oppose LD 881 and LD 882. I feel like this is another way for the big business to come in and overtax small businesses. I know last year OMP had proposed changing height of seedlings and it was shot down prior to this. I believe you were in session with that. And I think that a lot of the things that they're doing this session is identical to what was already put and tabled and told no last session. Like we are continuing to fight the same fight every Monday that they want us to go in front of them and decide whether or not we want to keep our jobs. It's a burden just to come and be in before you guys. On 882, the bill would turn OMP into judge, jury, executioner. No department should have this type of power. Essentially, they want to police us. They want to fine us. They want to execute the punishments. This should be put before a completely separate committee. I understand coming in and finding people with wrongdoings and saying, hey, I'm going to give you this, written sanction. You go before a separate committee and then they execute fees and fines. I think that giving any department that type of power is really, really a gross overstep. We're America. We have checks and balances for a reason. Finally, I want to just briefly support LD 939. I think that all of the talk about the retail stores is important because, like Mr. Petterman just said, we're required to retail 25%, which means me as a small caregiver, I can only wholesale 75% out. And then I'm burdened with either setting up a delivery service, running an at-home office, or opening a store, which is something that they're clearly trying to stop us from doing. So I just want to reiterate, I know that we say it almost every time we come before you guys, but this is what feels like an attempt to sabotage the medical program. No other medical program in the state is ran by the VLA. It's all in DHHS. I don't see anybody governing methadone on VLA. And I think that it is a gross overstep to have even put us on a different committee. So that's about all I have for today.
Thank you, Ms. Patterson. Any questions from the committee? Seeing none, thank you for your testimony.
Have a great day. Thank you.
Next up, we have Catherine Lewis, and she'll be followed by Donald Gardner.
Good morning. Good morning, Senator Lucchini and the rest of the committee. I appreciate the moment to speak. I fear I have more testimony on all these different bills than I have time to give. But I wanted to make sure that I got a couple minutes in here. My name is Catherine Lewis. I represent Medical Marijuana Caregivers of Maine Trade Association, as well as my own caregiving business with my husband. I wanted to let you know that I am opposed to LD 881 and 882. In part, if not by whole, 881 because of the retail license for the stores, the cannabis stores. We shouldn't have to have a separate license for the stores that we're already paying for. The application clearly states a question whether we're having a store or not. So the state is already aware, and we don't need a separate licensing fee for that. The state has an overabundance of licensing fees already. That's not necessarily being used for the program directly. So we don't need the extra fees. LD 882, though, is the one that I oppose more stringently because of the fact that we're looking at forfeiture and fines for patients if they are found to have overabundance of plants or product. That is going to be very difficult to enforce, as the patient is allowed 8 pounds if they grow it themselves, as well as they're allowed to grow 3 adult use plants if they're over 21, and they're allowed to keep all that those plants provide. So how are we going to tell if they're 1.25 ounces over or 2 ounces over, and then we're going to penalize a patient? They're going to be subject to forfeiture immediately, and then they'll have their day in court where they have their affirmative defense after it's already been removed from them, whether it's the plants that they don't get back in usable condition when it's found that they're okay to have it. It's too late then. You can't pour the milk back off the ground. Very, very important that this one be stopped right now, right here. We're looking at unenforceable legislation. That is all I have on these two bills at this time.
Thank you, Ms. Lewis. Any questions from the committee at this time? Seeing none, thank you for your testimony.
I will be submitting detailed in writing. Today's been a hard day. We've got staff out for COVID, so we're shorthanded.
Sorry to hear.
Yep, so you'll get
All right,
some
thank you.
more in writing. Thank you.
Great, thanks. Okay, next up we have Donald Gardner. He'll be followed by Dawson Julia and Grant Ellis.
All right.
Welcome, Donald. Yep.
Hi. Hello. Good morning, Senator Lucchini, esteemed members of the VLA. My name is Donald Gardner. I'm a patient and a caregiver in Washington, Maine. I run Stonehouse Gardner, my own independent business. I come before you today in opposition of LD 881 and LD 882. So I'll start with 881. Basically, the OMP planning to, I'm just against the changing the plant size. Asher Putterman, he already kind of, I'd be just repeating what he was saying. I'm an outdoor grower. We're trying to breed for disease resistance, things that Gunderson is already saying, like, we want to test for disease. We want our stuff to be disease resistant. If we want it to be disease resistant, then we need to be able to grow our plants to the proper size and sex them out and find the right traits that we need. So if we're limiting our plant size, it doesn't work. That's very counterproductive to what we're doing. And as someone before me already spoke, this has been put before you before and it's been shot down. So it doesn't really make sense why the plant size is being decreased. And I'm seeing as both these bills are being rolled into two, and instead of having 6 minutes, we only have really a minute and a half per. I'm going to roll right into LD 882. Basically, to summarize LD 882, it just gives OMP too much power. It's an overreach of power. It's too much. Even these scales of fines, like of upwards of $2,000, like something like that, that's enough to sink me. Someone like me, it'll sink me. So it doesn't make any sense. It's basically like someone said before, like it's making OMP judge, jury, and executioner. It makes no sense. If you're gonna fine people, they should be put before a separate party, not the OMP. It does, neither of these make any sense. And both of these are, as Gunderson said previously, they're trying to basically merge the programs, or not merge, but align them. 30 seconds, thank you. They're basically trying to align the two programs. They are two separate programs. We've already said it multiple times. The person who smokes a joint recreationally in the weekend is someone completely different than the person who uses it for medicine, like myself. And thank you very much. I've got 7 seconds. I'm going to wrap it right up. I tried to keep it short and sweet. Any questions? I appreciate all of your time. Thank you.
Thank you, Mr. Gardner. Any questions from the committee this time? Seeing none, thank you for testimony.
Thank you very much.
Okay, next up we have Dawson Julia, followed by Grant Ellis, followed by Jennifer Bergeron. Welcome, Dawson. Yep.
Hello. I can't see myself on here, but I'm hoping you guys can see me.
We can see you, yeah.
Okay, great. I just wanted to start off. My name is Dawson Julia. I'm a director of the Maine Cannabis Coalition, and I also am a caregiver. I own a storefront in Unity, Maine, East Coast CBDs, and I am definitely in opposition of 881. I'm in opposition of 882, and I'm in opposition of 1029. And some of the highlights I'd like to point out, I think a lot of people have already mentioned, why do we keep changing the plant size? And you know, I think we have 24 inches. I think that if we want to harmonize the two programs so that everybody has the same plant height and stuff, then we should just make the adult use be to 24 inches. That's a simple fix that I think everybody can agree. Make it easy for the inspectors and stuff, or whatever the reason is. But you know, the big issues really at hand here are what I'm seeing is 882 specifically, the department administrative holds. I want to point out something very important. These departments that we're talking about, these issues like pesticide issue. We have a pesticide department in the Department of Agriculture. We all get certified licenses from them that shows that we've done our training. And those guys are experts in that. If they have a pesticide problem, we should be using our best tools for that in the Department of Ag. We don't need to reinvent the wheel in OMP, a branch that barely knows anything about cannabis. Why would, in God's earth, would we want them to start handling pesticide issues? And that goes the same for a bad food product. Let's say it's an allergen, or somebody eats a bad brownie that was made with bad eggs or something. OMP, yeah, they can pull the products off, but what are they gonna, this is a HHS, this is the Department of Ag again. They already have safety protocols in place. And I feel like that's the appropriate place. And that's really what LD 1539 opened the door to and directed the OMP to do, is to take, and when you have issues specifically that deal with other departments, use those other departments. And that should be the direction I feel we should be going. The $10,000 fines and stuff, the horrifying thing to that is it seems like it's just wide open. It leaves the department full discretion to decide what's a $10,000 fine and what's a $10 fine. Everywhere else we see in the statutes of the medical marijuana program since its origination shows that if you are guilty of fraudulent activity on your application, it's up to a $200 fine. If you are guilty of smoking in public, that's a $200 fine up to. If you are a confidentiality violation, that's a $1,000 fine up to. So let's define each issue and let's make it a fair, safe thing that everybody can easily understand and not give full discretion to, you know. So I guess I'm out of time, so I'll leave it at that. And I'll be here for the next ones too. And if anybody has any questions, I'm available. Thank you very much.
Great. Thank you, Mr. Julia. Any questions from the committee? Representative McCray.
Thank you, Mr. Chair. Thank you, Mr. Julia. I'd be interested to hear, you were just laying out your suggestions about different levels. Could you put that together for the work session? I'd like to see that.
Absolutely, absolutely. I'd be happy to do that. And as far as the different tiers go, I would say that I think there's something that can easily be, everybody can find an agreement that it's a fair system. I mean, it's not like we don't want to be fined or anything. I just want to make that very clear to all the members here. We're not saying zero regulations or zero fines or anything like that. We're saying common sense, easy to understand. We all want to be able to look at maybe have a list of all the different things that just shows like if you're hunting and fishing, you know, if you catch a fish that's too short, you know what you're going to be paying for a fine. And that's the way it should be in all our programs. Transparency is what I call it.
Thank you.
Yeah, thank you for the question.
Any other questions for Mr. Julia at this time? Seeing none, thank you. Testimony. Oh, hold on, Dawson, if you can for a second. Representative Wood.
I'm sorry, Mr. Chair. I thought
Okay.
I had my virtual hand up. It went away. Mr. Dawson, I was looking for you. Two questions. The first is, are there currently no fines? And this fines for caregivers is new?
Yes, there are fines currently, and those fines get distributed to the OMP funds for any violations that they collect on. And like I mentioned, there's privacy confidentiality fines that are up to $1,000.
Okay, that's current.
Yes, currently there are fines available for specific issues. Fraud is another one, smoking in the public, things like that.
I was just confused between what's the current state and the proposed state. So I think what Representative McCrate asked for will help answer those questions so that we can just see what the changes are. My other question was, where did it go? Oh, the size. You talked about, are we trying to merge the medical and the adult together? What's the size in the adult use program for immature plants?
Well, I believe it's still 6 by 6 inches, if I'm correct. Is that right, Susan? Yeah, 6 by 6 inches, which was really a mistake when that law was originally drafted, I feel. And I think a lot of the adult use cultivators are realizing these numbers need to be corrected. They're not big enough. And I agree with that. But the 24 inches is real important for the medical program because a lot of Maine citizens and patients are growing for themselves. And so if we made it 24 inches for both adult personal use and medical personal use, we're giving those outside growers a bigger chance. Our growing season is short. We're in the Northern Territory. So the bigger our plants can get when we put them outside at the end of May, the more harvest we can have, and those patients can have a supply that hopefully will last them throughout the winter and spring months. So it's just a common sense thing that I think really, it doesn't hurt anybody to make it 24 inches, but it does help a lot of people to make it 24 inches. So why go the wrong direction?
Okay, thank you.
Thank you for asking the question.
Any other questions from committee members at this time? Seeing none, thank you, Mr. Julia.
Thank you, sir.
Okay, so next up we have Grant Ellis. He'll be followed by Jennifer Bergeron and then Alicia Melnick. Welcome, Mr. Ellis.
Good morning, Mr. Chair. Thank you for having me, and good morning to members of the committee. My name is Grant Ellis. I'm a disabled medical cannabis patient, and I'm the president of the Massachusetts Cannabis Reform Coalition. Currently from Cambridge, Massachusetts. When I was recovering in Maine, I was in Waterford, Maine, after I fell disabled following complications from a surgery. And part of the reason I'm testifying today, I want to echo a lot of what has been said in regards to opposition to LD 881 and LD 882. Not all of the provisions of both of those bills, but a number of the provisions in each bill I think would have a negative impact on disabled and homebound medical patients like myself. Number one, with LD 881, I think the fact that provisions of the bill were included incorrectly related to making caregivers have a separate license, that alone tells me that the bill shouldn't be supported at the time, and rather than being amended, perhaps it should be redrafted from the beginning with input from stakeholders and others. It's worrisome that the department asked for this change to caregivers having a retail store versus how things operate now, when they think their current rules allow them to do what the proposed changes would enable. So just some clarification there would be helpful, in particular as to if the current rules require what OMP thinks the proposal in LD 881 was going to allow them to be able to do. Are there any added costs that patients are going to encounter were the proposed changes in LD 881 to go forward? It sounds like there wouldn't be, but just making sure I think is important. And then on the plant height issue, I just want to echo what Mr. Julia said, which is I think it's more crucial to bring the plant height up on the adult use side rather than change the medical plant height. If I were, I've been thinking about going back to Maine, but even if I weren't, I know medical patients in Maine who do home grow, and they are worried in regards to 882 about exactly what was being talked about earlier in LD 882, which is that they could be subject to fines or forfeiture of their medicine if their medical grow goes over even though they're allowed to have an adult use grow. So I think to clarify that, it makes a lot more sense to align the adult use home grow and the adult use plant limits with the medical use plant limits, rather than reduce the medical use plant height, which will only end up hurting patients. So thank you very much. And I oppose those two bills.
Thank you, Mr. Ellis. Any questions from members of the committee at this time? Seeing none, thank you for your testimony. Okay, next up we have Jennifer Bergeron. Welcome.
Thank you, and good morning to you all. Since I have very limited time, I'm just going to start right off, except I'm Jennifer Bergeron. I'm a caregiver in Waterville, and I live in Winslow. I oppose 881, 882, and 1029. These bills, you have heard already some testimony as to why other people oppose those. So what I'm going to speak to is Director Gunderson's testimony this morning, where he said that there was consensus in the stakeholder meeting, and the meeting that he is talking about, 4 of us are on a separate Zoom here, and we're all in attendance at that meetings, and we have recordings of the 2 days of those meetings. There was no consensus. So I can tell you that it was a negotiation where the department was trying to have some give and take. And now the department is claiming that we gave on everything that they're now proposing, but they're still taking in other areas. Like they didn't put forth that caregivers can cultivate 100%. So they didn't put forth that caregivers can change from 500 to 1,500 square feet. So there was a lot of discussion in that stakeholder meeting. And anytime that you hear that there was consensus, you need to kind of remember there was no consensus, and that was a negotiation. I personally was approached by Dan Walker at that meeting, who I believe is Curaleaf, and was told if we would fold on the residency issue, then we would have everything we wanted out of that stakeholder meeting. We did not fold on that issue. And it seemed as though he had the authority to make that offer to us. So I don't know why somebody who is a dispensary representative would seem to have authority to give caregivers anything, but that's how it seems to work here, is the department seems to be in lockstep with whatever the dispensaries want. So I want to make it clear that what he said about us having consensus in that stakeholder meeting was not accurate. Just that's as clear as I can be on that. Also, many of the things that are being asked for by the department, it seems as though everything put forth, and I'm sorry, the clock always distracts me, everything being put forth as consensus is always in the direction of something the department wants that makes it worse for caregivers. Anything that we asked for in that meeting that would make it better for caregivers, that doesn't ever seem to make it into this discussion. My time is up, so I think I'll leave it there.
Thank you, Ms. Bergeron. Any questions from the committee at this time? Seeing none, thank you for your testimony.
Thank you.
Okay, next up we have Alicia Melnick, and she'll be followed by Melina Dumas. Welcome, Alicia.
Thank you, and my apologies for missing you calling me earlier. The first name by alphabetical caught me off guard. My name is Alicia Melnick.
Figured out our system.
Yeah, my name is Alicia Melnick. I am a resident of Portland. I am a member of the commission to implement the marijuana laws in Maine, and I work with the Maine Craft Cannabis Association. I want to speak briefly today about LD 882 and apologize if some of this is repetitive. I think as you've heard, the caregivers that we work with support the concept of graduated sanctions and appreciate that the department and OMP expresses a commitment to addressing intentional and unintentional violations through warnings and, where appropriate, remediation. Unfortunately, the bill before you doesn't provide much clarity about what kinds of violations would trigger minor versus major level fines. And as drafted and understood, the fine levels are out of sync with the severity or public health and safety risks of some of the violations that were suggested during some of the stakeholder meetings that you've heard about today, and are certainly beyond that which many small to medium businesses would be able to withstand. Because there is so much uncertainty about which violations could trigger which level of fines, we have major concerns. And if the committee decides there's a need for an additional administrative holds and a new fine structure, we ask that you look to other similarly situated industries and behaviors to provide more guardrails and reliability for the caregivers and patients that would be subject to such sanctions. In particular, since we're talking about an industry and behaviors that, if not in line with Maine statute, could expose people to very serious criminal prosecutions and sanctions. Just real briefly, I had to triage some calls this weekend from a member who was very concerned that they hadn't received their registration renewal that was supposedly mailed over a week ago. This sort of minor violation in 2021, where we can't find a way to get someone who is trying their hardest to be in compliance their registration card in under a week of mailing and haven't been able to figure out how to help this person retain their business without exposing themselves to criminal violation is really concerning. And those are actually the kinds of things that I wish we would be talking about today in the department bill, because those are the sorts of issues that we really have no idea. Would that be considered a major violation, exposing this person to $10,000, tens of thousands of dollars of fines, and also putting them at risk of criminal state and federal prosecution? So again, caregivers are not opposed to reasonable oversight, including testing measures and graduated sanctions. But we want to look to what is the norm in other industries and what are the true public health and safety risks. So if this committee seeks to do that, we really hope that the department would be able to provide more evidence of the basis for these sanctions and what the specificity of what would be a minor or a major violation. Thank you for your time.
Thank you, Ms. Melnick. Any questions from the committee at this time? Seeing none, thank you.
Thank you.
Okay, next we have Melina Dumas, followed by Mark Barnett, and followed by Joshua Drew. Welcome.
Thank you. Good morning, Senator Lucchini, Representative Chiazzo, and members of the Joint Standing Committee on Veterans and Legal Affairs. My name is Melina Dumas. I'm an attorney with the law firm Drummond Woodson. I'm here today on behalf of Maine Organic Therapy Remedy Compassion Center in Curaleaf, Maine. And I'm going to take my time this morning just to speak to LD 881. We support LD 881, which makes important practical and technical changes to the statute for the purposes of improving implementation and enforcement. We understand that OMP is proposing an amendment to remove the separate caregiver retail store registration certificate requirement because the proposed medical marijuana rule already requires the production of showing local authorization for a caregiver retail store and other uses as part of the caregiver application and renewal process. If that changes, we'd recommend that the legislature revisits this. And I think it's important to take some time to provide context on the existing requirements in the statute for local authorization for caregiver retail stores in particular, for the sake of clarity of this discussion. The medical marijuana statute is already clear that the operation of a caregiver retail store requires local authorization. A caregiver retail store is defined in statute to distinguish a store from standard authorized caregiver activity. Local authorization was an important compromise that stakeholders made years ago. Caregivers wanted the ability to open retail stores to expand their business opportunities, and municipalities were concerned about their ability to control the expansion and proliferation of businesses in their communities. Stakeholders that did not support this expansion agreed to not oppose the amendments so long as local authorization was required. Language was included in the amendments to the medical marijuana statute from 2018 to prevent municipalities from shutting down caregiver retail stores that were already operating with municipal approval as defined in the statute prior to the effective date of those local authorization provisions. It is not, however, a right to operate a store wherever one wants without local approval. But caregiver retail stores are continuing to pop up across the state in towns that have either not opted in or have not granted all the necessary approvals. It may be helpful background to note that when Maine voters voted to legalize medical marijuana, retail stores were not contemplated. If you look at the voting numbers in communities across the state for legalizing adult use marijuana, you'll see that many towns did not support adult use marijuana sales. So it's completely reasonable for towns to be able to decide if they want to allow either medical or adult use retail stores or not, and that's what the law currently requires. The change to the legal definition of seedling also matters from a practical perspective for tracking, plant transfer, and enforcement. As Director Gunderson mentioned, the 18 inches was a compromise. The number that the legislature lands on does not really matter. It's 18 or 24, another number, but consistency is what's important. It's already possible for medical marijuana plants to be transferred to adult use cultivation facilities under the transfer provisions in statute, and it's important for the definitions to align for that reason. Finally, the change to the calculation of plant canopy fees is an important technical fix. Currently, caregivers electing the canopy option still have to identify the number of mature plants they'll cultivate within that canopy limit. And the amendment would place a reasonable cap on the number of fees, which will reduce costs for registered caregivers electing that option and simplify the registration process. Thank you. I'm just at my time.
Yeah, you got it. Thank you. Any questions from the committee at this time? Representative McCray.
Thank you, Mr. Chair. Thank you, Ms. Dumas. I need some help in understanding your testimony about local control. Can you be specific about what you're looking at in the bill that concerns you?
So I was actually commenting on the other testimony that we've heard today, which seemed to be opposing what was initially in the bill because it demonstrated that there's going to be some sort of local approval requirement for caregiver retail stores. So I just thought it was important to mention in this testimony.
Oops.
Oh, I think Ms. Dumas may have frozen. We can reach out to her, Representative McCray, with that question before the work session.
Yeah, I think I understand where at this point. Yeah, it was different than what we'd heard from anybody else.
Gotcha.
Thanks.
Okay, so at this point, we will move to Mark Barnett, who will be followed by Joshua Drew. So welcome, Mr. Barnett.
Am I on here? Good morning.
You're on, yep.
Thank you, Chair Chiazza, Chair Lucchini, distinguished members of the committee, again, for the time to speak before you today. My name is Mark Barnett, resident of Auburn, registered caregiver, own a medical retail store in Portland, Maine, and executive chair of the Maine Craft Cannabis Association. A lot has moved around this morning, and of course, there's a lot to jam in here. So sorry if I jump around a little bit. We would recommend that the committee reject LD 881 and 882. Of course, LD 881, it sounds like there has been a positive amendment to that bill to remove that certification process for a license, which would have basically abrogated a caregiver's right to operate a store with local approval by inserting another step. And we have seen in the draft rules and the proposed rules that the Office of Marijuana Policy has put forward that they intend to make that an almost impossible task for most of the small businesses that participate in the caregiver program. So even though that amendment has or been suggested, I just want to make sure that we are out there that we firmly oppose any such move. So sorry to, again, have to audible a little bit here. I wanted to respond a little bit to the previous testimony, only in such as it affects the testimony I was going to give and this bill. Just a comment about the voters not contemplating caregiver storefronts. It's a little mind-boggling because if that were the metric that we were going to use, I think we would probably scrap all of the adult use programs, since the referendum that voters passed looks nothing like the adult use program, which is part of the problem that we have here today, is that program was essentially hijacked and turned into a sort of corporatist, incredibly expensive, difficult to access program. And now we're trying to align the medical program, which is none of those things, with that. So any moves in that direction, we are going to oppose, as will essentially all caregivers and the tens of thousands of patients in the state, as I'm sure you've heard already so far this session. On LD 882, which we also oppose, I think it is important Ms. Bergeron's testimony. We were also present in the room during those discussions with the department. My takeaway from those was very similar. Oh, thank you. 30 seconds. Ms. Melnick said earlier, all of our members actually support stepwise punishments for violations, but I don't think any of the fines levels are reasonable. I wanted to point out that you could have a $10,000 fine if you compare this with the proposed rule for using metrics software wrong. Metrics software was sold to us by consultants who are also making money from writing rules requiring that metric software.
And Mr. Barnett, your time has expired. If you can wrap it up real quick.
Yep, absolutely. $10,000 price tag is half the fine for assaulting a person with a deadly weapon here in Maine. It's also the same fine you'd get for illegally selling liquor without a license twice. So we just would be creating large financial incentives for abuse that future inspectors or administrators might find compelling, especially if those administrators were intent on pushing businesses and their patients out of the medical program. Thank you. Be happy to take any questions, and I have much more detailed testimony that I've submitted on each of these bills.
Great, thank you, Mr. Barnett. Any questions from the committee at this time? Representative McCray.
Thank you, Mr. Chair. Mr. Barnett, did you want to comment on the size issue that is included in one of the bills?
Yeah, I mean, I certainly refer to it in my written testimony. You know, I think the cultivators who have given their feedback on why that is at the current level and what the history of that has been, I think I would leave that to the experts. Again, I think the bigger question is, why was this change made? Where did it come from? Was there any, consultation with a farmer, much less a cannabis cultivator? And, when we're looking at the kinds of rules that are being proposed, the rules and bills that are being proposed by the department, what technical knowledge are they relying on? That's, I think, a really serious question that remains unanswered. Thanks for that question.
Representative Corey.
Thank you, Mr. Chair. I've always been sort of confused why we would be getting into size requirements anyways on sort of vegetative plants and seedlings themselves. The thing that I've always been most concerned about is sort of what people are yielding and, what kind of predictability that adds to tracking itself. Essentially, I learned a lot about this stuff when I was sat on that marijuana legalization implementation committee. What really matters to me is sort of if a plant is flowering or not. It's in that final stage where it's under a 12-12 light cycle, and it's going to actually be producing flower with a move, and especially in the caregiver space right now, where we've gone to actual plant count, or from plant count to canopy space, 500 square feet of canopy space. People are growing all different sized plants, so I don't understand why the size of a seedling actually matters. Can you explain sort of what the thought was maybe behind them caring about seedling size as opposed to how people are actually growing? And I'm sorry, it's a long question, but I'm sort of confused why people are actually interested in size of seedlings.
I concur, and I share your confusion, except I think I have a clear answer. I just real quickly, since you mentioned the canopy piece, there is in one of these bills, I forget which title, I think 881, does make the required adjustment so that the canopy fee can be similar to the plant count fee. But given what else is in this vehicle, I think it would be more appropriate to address that with LD 939, which you will see later today, which also includes that fix. Thank you for bringing that up, Representative Corey. And to your question about plant size, unfortunately, I think the answer is very simple. The department wants people to grow fewer plants and have less medical cannabis available in the program. Because with plant count, which currently does affect both, as you mentioned, the canopy people and the plant count people, you have very strict limits on your mature and immature versus seedlings. Seedlings are, generally not regulated the same way that immature and mature are. So the more plants that you can take out of the seedling bucket and push them into the immature bucket, the more you're limiting a cultivator's ability to produce product. So, unfortunately, my conclusion is that the reason to do this is to allow caregivers to grow less product. And I think that if we could think around this issue in a lot of different ways, you're still going to get to that answer. That's my opinion. Thank you for that question. I appreciate that.
Can I just ask a question real quick that clarifies this a little bit? So my concern, at least, within, the caregiver market, and why I think it was such a good move to, head in the direction of canopy space is that, all of the plants are different and they produce different, qualities, for each, type of, medical condition and everything else. So my understanding is plants are actually different sizes based on their strains and everything. So trying to fit within a plant count, model, I don't know, is that good for patient access to the medicine they need?
Yeah, I mean, I tend to share your view. I think that square footage is, and many caregivers have chosen to do it because of that flexibility and the different types of plants and being able to have a more, customizable. However, I do know that there are people who have been growing via plant count for by now, over a decade plus. So I think, those farmers' cultivation practices, their preparation, their seed selection, their own varietal selection is based around that. So we certainly wouldn't want to, see that option go away. We just really appreciate and thank you for being a part of making that happen. The option to use the canopy instead.
Yeah, I want to be very clear. I don't believe in getting rid of that. I just wanted to ask.
I didn't think so.
Thank you.
Thank you.
Any other questions from the committee at this time? Seeing none, thank you for your testimony, Mr. Barnett. Okay, next up we have Joshua Drew, and he'll be followed by, Paul McCarrier and Hannah King. So welcome, Mr. Drew.
Thank you. Good morning, Senator Lucchini and members of the VLA committee. My name is Josh Drew. I'm the owner of Dialed In Farms. I'm a member of the Maine Growers Alliance, and I am speaking in opposition of LD 881 and 882. I want to start with a quick snapshot of my background. I grew up in northern Maine. I worked on a variety of farms throughout my upbringing. I went to college at the University of Maine, Orono for horticulture, sustainable ag, and business. My plan was to be involved in the medical cannabis industry and keep it that way. I feel extremely irritated that OMP has decided to use an outside consultant who just took a job of working for Philip Morris and Constellation Brands, among other corporate Goliaths. I know people personally that work within the Colorado cannabis industry, and when Andrew Friedman changed the framework in that state, just completely decreased the quality, and the medical program is now viewed as terrible by many of my peers there. When I read these new OMP bills that are going through, I see right through the quote national best standards lingo. We are being force-fed. In my opinion, this is a deliberate attempt by OMP to make it harder for small businesses to operate within the medical marijuana program and to try to merge folks into the adult use program. It seems OMP has used zero data to formulate these major policy changes, basing their program off of demands of corporate industry leaders and lobbyists with vague references to public health and safety crisis arising from the current Maine medical marijuana program, which we have been shown no data. I guess all I can say is look at who's supporting these bills so far. Lawyers that represent large multinational cannabis companies like Curaleaf and Acreage Holdings and OMP. Everybody else is against it. I feel OMP is on a crash course to ruin the lives of so many good Mainers in a time when we should be embracing businesses that are succeeding during this pandemic, which has now lasted over a year. It's absolutely disgusting to me that OMP is using this pandemic as a political tool to push through these regulations when we can't even show up in person to fight for our rights. I'll leave you with this. Maine doesn't need outside consultants telling us how to run our program, and we certainly do not need corporate companies and their infinite funding to dictate how our program should be operated. We have qualified Mainers like myself who have been in this industry, who are well educated, and who are stakeholders that want to see Maine's medical program continue to prosper as we have seen these past few years. I won't have time to be involved in the next block, but I do support LD 939. I think that is a push in the right direction, and everything in that bill makes complete sense and is way better for the state of Maine than what you are seeing proposed by OMP. Thank you.
Thank you, Mr. Drew. Any questions from the committee? And I'd add, if you haven't already, you can submit written testimony on those later bills where you can't be here. So
I will be. Thank you.
Great. Seeing no questions, thank you for your testimony.
Thanks.
Okay, so next up we have Paul McCarrier, followed by Hannah King. Welcome, Mr. McCarrier.
Welcome, thank you. Hope everyone's doing well this morning. My name is Paul T. McCarrier. I'm a member of the Craft Cannabis Association, and I've been involved with the medical cannabis program for 11 years on the cultivation, retailing. Now we're doing a little bit of baking and the public policy end. I'm here today to testify against 881 and against 882. Well, it is reassuring that the department has decided to offer a friendly amendment to remove the section involving caregiver retail stores. It is really disturbing that they're again trying to reduce the size of seedlings that patients, caregivers, and dispensaries can have in this state. When we're talking about plant size, it's very important because we're limited on the number of plants to be able to have a certain amount of wiggle room on how plants on your cultivation end, because plants grow, obviously, if you're doing well. And so one day you could be going from having a plant that is 22 inches to where it could jump to 25 inches. So when we're talking about actually adjusting the size of the plant, this could have a very detrimental effect, especially when you're trying to include astronomically high fines as $10,000. You know, when you're looking at criminal penalties, I believe it's a Class B felony that has a fine up to maximum fine up to $10,000. And when you're trying to make drastic adjustments, such as reducing the size of the seedlings from 24 inches to 18 inches, that's something that is really going to be detriment to the industry. It's going to affect our cultivation practices. Employees are going to have to be retrained, and patients are going to be having likely less access to different varieties of cannabis. One of the things that I want to hit on also when we're talking about the fines and violations is the fact that over the past year, there were only 185 complaints. I know that Director Gunderson mentioned that there were 186 complaints, but one of those, which involved a product, was tested and proved to be unsubstantiated. So when you're talking about a program that has over 3,000 people, 3,000 commercial participants in it, I think that's pretty good that there was that low level of complaints. We have been asking the department for months for specifics on what type of complaints these are. Are these complaints from patients? Are these complaints from municipalities? Are these complaints from other providers? And we have yet to see that data. I hope that's something that the committee will dig a little bit deeper into, because if the department is going to be data driven, I think that data should be open and available for the Committee of Oversight and also for the public. When we're talking about any sort of future interactions with the violations or possible testing, I think it's very important to bring up that the Board of Pesticide Control needs to be involved with this. They are the experts, according to the state of Maine, when it comes down to pesticides, what is safe to use, et cetera. And it seems like there is some sort of wall between them and OMP when it comes down to actually determining what is good and safe practices. So that's something that I'm hoping that, again, this committee will look into, this committee will get more involved with. And if we want to make good decisions, I hope we have good data, because we are being asked to change to a system that is a metric that is supposed to be all data driven. My question is, where is that data going to go? Will that data be available for us? And if the department already has issues collecting data within their own house, I don't think it's appropriate for them to try to push additional data collection requirements upon the industry participants if they can't collect enough data for themselves and produce data for the Committee of Oversight or for the people who are registered in their program.
Thank you, Mr.
On that
McCarrier.
note,
Your time has expired. If there
well, thank you very much, and I just hope that you would consider again to really look at the data in this, so we can all make better
any questions
decisions.
from the
Thank you.
committee at this point? Seeing none, thank you for your testimony. Okay, next up we have Hannah King. And she'll be followed by Mark Ferrero and Mike Wilson.
Good morning, good morning, everyone. Senator Lucchini, Representative Casio, members of the VLA committee. My name is Hannah King. I'm an attorney with the law offices of Drummond Woodsum, and I represent Maine Organic Therapy, Remedy Compassion, and Cureleaf Maine. And I'm here before you today to testify in support of LD 1029 and LD 882. I'm going to start by speaking to LD 882. LD 882 would provide the Office of Marijuana Policy with a range of tools to ensure industry participants are complying with the law. This is necessary to protect both industry and consumers. Right now, the only enforcement action that Office of Marijuana Policy can take is to revoke a caregiver or dispensary registration, to revoke their license to operate. This is a draconian action that should be reserved for intentional violations that have a direct and adverse impact on public health and safety. However, without fines or other administrative tools for progressive enforcement, regulators will have no choice but to either revoke a caregiver or dispensary's registration for lesser offenses that still merit enforcement, or in the alternative, not take any enforcement action, which means industry would have no reason to comply with what are also important public health and safety provisions in the law, putting patients at risk. One of the reasons why we have fines in place for when we're trying to regulate is that it's a deterrent. So not only are you enforcing against people who are not complying, you're also creating a broad deterrent that's encouraging people to comply, particularly when there are financial reasons not to comply. And there are a few things that are important to note. First, the amount of the fines are significantly less than those that the regulators can assess against the adult use program. Also, the larger fines, up to $10,000, are reserved for larger operators, dispensaries, manufacturers, and retailers. The maximum fine that can be assessed against a caregiver is $2,000. Further, with regard to kind of what conduct would be fined, the adult use marijuana rules provide a guide as to kind of how this would be implemented. Under the adult use marijuana rules, there are 3 different types of categories of violations: major license violations affecting public safety, major license violations, and minor license violations. So even major license violations include things like deliberately purchasing marijuana plants, marijuana products from out of state or from outside the licensed program. Major licensing violations affecting public safety include intentionally selling marijuana or trading marijuana products for controlled substances. It seems as if it would be important to also enforce against similar violations in the medical program. There was a lot of talk about the fact that Office of Marijuana Policy shouldn't be the ones who are enforcing this, but that's what every regulatory authority in the state does. That's what BABLO does. That's what the folks who regulate gaming do. And there is a process for challenging enforcement actions, and this process includes an administrative hearing, and as with all final agency actions, consideration by the Superior Court. So we strongly encourage you to vote ought to pass LD 882.
Thank you, Ms. King. Any questions from the committee at this time? Seeing none, thank you for your testimony.
Thank you.
Okay, next up, we have Mark Ferrero. Oops. Okay. Who I'm not seeing unless he just jumped to the top. Oh, there he is. Got it. Okay, so Mark Ferrero, followed by Mike Wilson, and then Nicholas Evans.
Hello, can you hear me?
Yeah, we can hear you, Mr. Ferrero. I think we can hear somebody. I think it's you. Yeah. We don't see you yet, though. Just see.
I'm working on that. Give me just 1 second.
Okay.
Well, we may just have to do audio only.
That's fine. People do that all the time. It's your call.
Well, good morning, Senator Lucchini, distinguished committee members. Thank you very much for taking the time this morning. My name is Mark Ferrero. I'm a store owner. I'm a member of the Maine Craft Cannabis Association. Prior to this, I've served as a certified water operator for the state of Maine for a small water system for a school. And I also served as an EMT for a number of years, licensed by the state. And I reference those two prior jobs in regards to some of the safety issues that we'll bring up later. I believe strongly in the health of my patients and of the outcomes from their use of cannabis. I'm testifying in opposition to these bills. Having had a new store, I relied on the knowledge base and the guidance of the OMP. The front end staff, Ginger, Nicole, Nikki, to name a few, have been knowledgeable, responsive, and overall incredibly helpful. And they've really worked to ensure compliance with program rules. The OMP heretofore has focused on a non-punitive approach, and the language in LD 882 in particular swings the pendulum to a variety of punitive measures for which the violations themselves are very ill-defined. Once again, we ask the OMP, where is the data to support changes of this magnitude? There seems to be a premise that the program participants, even patients, are exploiting the rules for nefarious purposes. And just one example, a patient who is found to have an excess amount may be in that position for having just a few ounces of overage, a 2% discrepancy, which could result in loss of their medicine. I absolutely want regulation. I worked, as I stated, as a water operator. We follow those program rules, particularly as an EMT. We follow all of the rules of that program. But we need regulation that is reasonable, with a fine schedule that's graduated and in line with the degree of the violation at hand. In another life, I also have a bachelor's of science from the University of Maine, a lot of plant science background. The Department of Ag should absolutely be brought on board for all pesticide, herbicide, fungicide issues. They are our local experts. They are the ones who should be in charge of that. And what I really want to speak to ultimately is that the punitive measures seem to speak to a tone that I've just not experienced before in my, being regulated by these other bodies. There seems to be a presumption, which I wholeheartedly reject, that program participants are willing to expose themselves, to pay taxes, to secure all necessary licenses just to divert cannabis. It's an absurd position, in my opinion. Those who wish to grow cannabis illegally and perform, illegal sales are going to do that anyway. Program participants are trying to follow reasonable rules, and they expect reasonable regulation. Thank you so much for your time.
Thank you, Mr. Ferraro. Any questions from the committee? All right, seeing none, thank you, sir, for your testimony. Next up, we have Mike Wilson, and he will be followed by Nicholas Evans. So, Mr. Wilson, whenever you're ready, sir.
Morning. I just wanted to say thanks for having the opportunity to speak up on this stuff. I'm kind of new to this testimony stuff and honestly participating in government in general. So I think it's really cool that we get an opportunity to kind of see what's coming out and make comments on it. And also, it's really cool to see Craig Hittman on the panel here. We did some campaigning for him, so glad to see you up there. So I'm going to go into my comments now. So I'm here to talk to oppose 881 and 882. 881,
Mr. Wilson, I'm sorry, if you could just introduce yourself, where you're from, and what group you represent, if any. Sorry.
My name is Mike Wilson. I live in Portland, and I'm a caregiver. My company is Maine Craft Cannabis Inc. Not the association, just a caregiver company. Is that good?
That's perfect. Yes, thank you.
Okay, thanks. So the additional retail license thing, I guess I didn't really understand that. It sounds like maybe it was taken back, but I'm going to comment on it real quick anyway. I don't see any reason to require additional licenses to make business any more difficult for us. I think that we're doing really great. I don't have a retail store, and it is kind of a pain point for us to have to do 25% retail as our businesses have grown, and making that more difficult to do just doesn't make any sense to me. The seedling definition thing, I don't understand that at all. A lot of people have like cultivating is this, you're looking at plant size and stage of growth. So everybody has their own kind of schedules and production protocols worked out. I don't think as proposed, it really impacts me, but I think for some people it could have huge impacts with no potential benefit at all. I just don't understand a reason to want to change that. As far as Mr. Gunnison said, is aligning to adult use, I don't understand why it makes sense to align to adult use. You're going to upset a lot of people's production schedules for no benefit other than having to measure 2 different size plants. I just don't get that one. So I just don't see any benefit for us here, for the patients or the businesses or the state. It seems like more paperwork and a change that doesn't really benefit anybody. The other one, the fine thing, I don't understand why we'd have fines that are that high. The tier schedule sounds like a great idea. I think, almost all caregivers want to see a fine schedule and regulations for people who are putting pesticides in their products. I don't think anybody's going to oppose that. I think that it wasn't in there to review. What I read didn't have anything with a tier for it. It sounded like violations can be up to $10,000 at the discretion of OMP, which I think is way too much power to be given to this regulator at this point. They clearly aren't trying to help us. They're proposing rules that allow them to, basically hurt us. And as far as like, the people that are violating, I'd love to see who they are. I know that there's a lot of rumor, and I haven't seen them myself, but I know Wellness Connection is one of these adult use companies, and they have they have medical side as well. And I think they've been reported many times by their own employees for using pesticides. So I think we all can support that. I'll leave it there. Thank you for your time. Any questions?
Thank you, Mr. Wilson. Any questions from the committee? All right, seeing none, thank you, sir, for your testimony. You did a great job.
Thank you.
Up next, we have Nicholas Evans, and he will be followed by Ryan Ellis and then Samantha Brown. So, Mr. Evans, when you're ready, sir.
All right. Thank you for taking the time to listen to us. I am Nicholas Evans. I live in South Berwick, Maine, and I'm speaking for myself as a patient in the medical cannabis programs. I'm here to oppose everything right now for LD 881 and 882. Specifically with 881, I think a lowering of seedling height is a completely arbitrary and frankly misguided move. An important part of patients' access is the ability of these caregivers to be able to provide and develop, plants that have specific cannabinoid and terpene ratios that are going to be advantageous for other people with medical conditions such as myself. I do agree that we should not have registered caregivers operating retail stores with separate registration fees. That's just another barrier to entry for small business, which this whole program has been founded upon. Changes in the fees for plant count, I'm not so sure of. And then making stores subject to comply with local regulations makes some sense to me. Regarding 882, I'm again in opposition. I think that we should have some more conversations with people like myself and the other caregivers that have been, working to provide me with safe access to medicine for the past 10 some odd years. And, frankly, I don't see how any of this is going to help me or, veterans who are using this for benefit. And that's one of the reasons why, I think that we should, oppose all these things until we can get a better understanding of how they're going to impact not only myself, but the caregivers and business owners and their employees. So until we see some type of, report of how people are taking advantage or skirting rules and how these things will help and how they're going to impact our tax dollars and my access, we shouldn't be doing any of it. Thanks.
Thank you, Mr. Evans. Any questions from the committee? All right, seeing none. Thank you, sir, for your testimony. Next up, we have Ryan Ellis, followed by Samantha Brown, and Senator Lucchini's back, so I will turn the gavel back over to him.
Thank you, Mr. Chair. Yeah, so we'll go to Ryan Ellis, if you can hear us. Okay, let's see if Samantha Brown is there. Oh, welcome, Ms. Brown. We can start with you and then we'll try to get Mr. Ellis in. So welcome.
Good morning. My name is Samantha Brown. I'm from South Berwick. I'm opposing LD 881 and 882. I am testifying as a parent of a child patient with a pharmaceutical resistant catastrophic seizure condition. I support patient access to their caregivers and I support small businesses. I first want to back Jennifer Bergeron's testimony about the stakeholders meeting, as I was part of it also. There was no consensus. It was simply a bargaining chip for Curaleaf and Wellness Connection, and there was nothing in there that would help caregivers or patients. I disagree that lowering the height of seedlings after something we recently fought for is fair. Please leave it alone. I strongly disagree that the licensing structure for retail stores need to be established. I won't go into any further detail on that because I think that's been covered. 882, the bill creates large fines that would debilitate a small caregiver. No warnings. These new fees and penalties are in addition to other civil and criminal penalties pursuant to other laws and rules. It enforces department rules for track and trace, in which I recently had a conversation with one of the legislators who worked on the bill, admit that track and trace was added to the bill in order to gain something else. It was a total negotiation. This isn't about safety, and most of everyone here knows it. It allows enforcement, law enforcement in gardens. This community has been fighting this topic for years. How can one be a criminal over a safe plant? Because of fear-driven campaigns and people in your seats. It further authorizes the department to adopt more rules. I keep hearing the justification of the absurd rules that the department needs to create rules of the laws that the legislature passed. Well, that starts here in these committees. With influences from lobbyists and large corporations, the legislature has been trying to fix something that was never broken. And that concludes my testimony today.
Thank you, Ms. Brown. Any questions from the committee at this point? Seeing none, thank you for your testimony. Okay, so next we have Ryan Ellis. He'll be followed by Susan Meehan, Thomas Portlock, and William Chartier, and that's all that we have who registered prior to the meeting. So, Mr. Ellis, if you can hear us, welcome. Mr. Ellis, though, you are on mute, so I'll, yep. There you go.
All right, I've dropped you. We'll get you back here in a sec.
All right, we can hear you though. Yeah, good.
Oh,
Cool.
good. Excellent. My name is Ryan Ellis. I'm a resident of Freeport. I have a medical cannabis store up in Augusta. I also am a member of the Craft Cannabis Association. I want to speak against specifically the first bill, 881, I believe. The seedling part has been discussed. I am completely also in agreement that there's no need to change the seedling size. It seems like a small philosophical power grab more than anything. I don't see that there's any need to change something that wasn't a problem to begin with. Moving on from that, I also see that the department is looking to drop the registration part for the caregiver storefront. And I would just ask why it was even there in the first place. I would ask why, why there's so much overarching desire to mirror a program that has been operating pretty successfully for the last 10 years and 20 years in total, but effectively, as an industry for the last 10. When, you know, there's this constant dialogue of aligning the programs. Why aren't we aligning the programs with an industry that has existed for the last 10 years? You know, medical is healthy, robust. I'm sure you've all seen the, you know, the financial statements from last year's success. I imagine this year is probably concurrent with that. And so that's mainly my concern. I don't know why, you know, constantly there's this comparison between these two programs. One of them is just barely getting off the ground and not very well, and one of them is flourishing with a much lower threshold of regulation. So I think mostly to conclude, you know, these regulators need to be looking towards a program that's already running, a program that doesn't have hardly any violations whatsoever, a program where people want to compete, and that is the healthiest form of regulation. I think that's all today, unless you have any questions.
Great, thank you, Mr. Ellis. Any questions from the committee at this time? Seeing none, thank you for your testimony today. Okay, next up we have Susan Meehan, followed by Thomas Portlock, William Chartier, and then Ronald Jordan. So welcome, Susan.
Good morning, Chairperson Senator Lucchini and Chairperson Representative Chiazzo in the Veterans and Legal Affairs Committee. My name is Susan Meehan from Sweden, Maine, and Oxford County. I am also Secretary of the Maine Cannabis Coalition and a founding member of Maine Children for Cannabis Therapy. I moved to Maine in 2013 to access the best medical marijuana program in the country to treat my late daughter, Cindy May. Cindy May is a legacy and a champion of patient access in several states. Please Google her name. In my daughter's honor, I am a medical marijuana caregiver, currently non-cultivating, who delivers medicine to pediatric patients across Maine. I am in complete opposition to LD 881-882 and LD 1029. I was present at the stakeholder meetings on November 12, 2020, in which Director Gunderson testified about. There was no consent. Present caregivers would not agree to removing residency requirements for board members of Maine marijuana businesses. The other side basically walked out. We built this industry despite paid lobbyists. LD 882. I am opposed to this bill. Sorry, I have to find my, sorry. I am opposed to this bill. The bill contains some very strong language, not in favor of protecting our small businesses nor our patients. It reads similarly to the draft rules recently published by OMP. These fines are excessive and could easily result in an insolvent business. I want to talk more about some of the recent complaints, and specifically the recent complaint filed by a Maine medical lab regarding marijuana that the lab owner tested for pesticides. This is a fine example of how our businesses are self-policing. The lab owner tested and retested this batch prior to processing because it is the lab owner's standard operating procedures and because the lab owner cares about the safety of his patients. Ask OMP inspectors about this Bodenham lab. This is a premier example of a lab with an excellent operating procedures process and full OMP compliance. This product was disgustingly contaminated with pesticides, and it was a very large batch. Once pesticides are processed through a lab's ethanol supply, the ethanol is contaminated with those pesticides, so it can affect future batches. This lab tests every single batch that comes into his lab prior to processing. The Acadia incident, the user did not even know what product he was in possession of. This is user error. To reiterate, the product in Bangor tested clean. I am opposed to the merger of adult use and medical, and this bill seems like another attempt at this merger. As in regard to LD 881, 24 inches was not a random number. As Director Gunderson said, we discussed this last year at the stakeholder meetings, and in no way did we agree that it should change. There are very specific reasons for this. A plant at 24 inches can be sexed and cloned and is able to reproduce. Prior to that, it is like trying to have a child reproduce. It's not grown enough to clone and sex and reproduce nor survive Maine's environment when it gets put outside if it's an outdoor grow. Another problem I have with this bill is the actual using the word in its own definition is an English taboo. It's like saying a human child is a human child that is not a mature human child. The bill proposes that we call an immature marijuana plant. An immature marijuana plant means a marijuana plant that is not a mature marijuana plant or seedling. The definition doesn't make any sense.
Ms. Meehan, if your time has run out, if you can wrap it up, and it looks like you have a question.
Yes,
as well.
it's pretty much wrapped up. That I am in opposition to these bills. They don't do anything to strengthen the program to protect patients and protect our small businesses, but they further excessive power and shutting down our businesses. Thank you.
Thank you, Ms. Meehan. Representative Wood.
Thank you, Mr. Chair. Ms. Meehan, at the beginning of your testimony, you said something about board members and residency or something, and I'm not sure I've heard anybody else mention that. Could you just repeat that?
Absolutely. During the stakeholder meetings that occurred in November of 2020 that Director Gunderson testified about, he was talking about consensus, and we literally came to consensus on not one single matter in those meetings. When they asked us, the other side asked us, Hannah King and Dan Walker specifically, asked us if we would agree to releasing the residency requirements for board members of companies that operate marijuana businesses in Maine, and we said no way. And that basically ended all communication. We were told we were wasting their time, and all discussion ended, and we are done dealing with lobbyists on this level. We built this industry despite them, and they ended the communication when we refused to talk about releasing the residency requirements by statute in Maine's medical marijuana program.
Okay, thank you.
You're welcome. Thank you.
Thank you, Representative Wood. Excuse me. Any other questions from the committee? All right, seeing none. Thank you, Ms. Meehan, for your testimony.
You're welcome. I'll follow up with written. Thank you.
Perfect. Thank you. Next up, we have Thomas Porlock, followed by William Chartier. Let me see if he is in the waiting room. He is. I will move him up. And then Ronald Jordan. So, Mr. Portlock, when you are ready, sir.
Thank you. Thank you all for your time. My name is Thomas Portlock, and I'm a caregiver and co-founder of Emerald Organics in Buxton, Maine. I stand in opposition to bills 881, 882, and 1029. These bills are written at the behest of moneyed interests like lobbyists, by lobbyists like Andrew Friedman and lawyer Hannah King to serve large-scale corporations and crush the existing medical market. These arbitrary bills are just another attempt to limit the freedoms and output in a broad sense of Maine's largest agricultural industry. These bills are a lose-lose for both the industry and the state, as it limits the productivity of the industry through onerous regulation, and thus will drastically reduce the amount of tax revenue realized by the state. When both the state and the industry loses, then the only motivation behind these bills clearly is to serve the needs of large and or out-of-state corporations in order to give them an unfair advantage in the future. Bill 882 makes OMP the judge, jury, and executioner, as Amber Patterson so clearly put it earlier, charging huge fines for violations of frankly meaningless laws like plant count, square footage, and possession of flower serves as just another vector for the state to extract more wealth from the industry. With bills like 882 being proposed, I see OMP as a parasite that seeks to infiltrate the industry and suck the value from our businesses. OMP's commitment to align the medical marijuana market with the recreational market illuminates very clearly they're trying to eliminate this industry, again, to serve large and out-of-state corporations. These boilerplate bills have been implemented in other states across the country and have been unbelievably destructive to medical markets, small businesses, and local economies. It is, on its face, sabotage. We've already surpassed the threshold of acceptable regulation in this industry, and I'm very disappointed that OMP continues to serve the needs of out-of-state corporations rather than its constituents that pay their salaries. I also state conduct a review of the motives of these bills and an investigation into OMP's immoral relationship with the corporate lobbyists behind this legislation. I'd also like to ask Eric Gunderson what percentage of the 186 complaints filed were actionable, substantiated claims. Gunderson and the lobbyists keep harping on, quote, public safety and, quote, best practices, and they're frankly very vague and insubstantial excuses, especially considering the lack of data provided to justify the increase in regulation that has an overwhelmingly negative impact on our industry, particularly small businesses. We should be working to decrease the regulations on the industry. I see the potential of this industry to easily exceed $1 billion a year in revenue. If done right, this industry will be a huge boon for the state for decades to come and provide more than ample tax revenue for the state. And when you listen to these testimonies today, pay attention to the fact that the only testimonies that are in favor of Bills 881, 882, and 1029 are lobbyists and lawyers that serve, again, the moneyed interests of large corporations who, with hollow words and meaningless justifications, are immorally using the state as a weapon to eliminate their competition. Thank you very much. That's all. Perfect timing.
Thank you, Mr. Portlock. My apologies for the interruption with the phone.
Not at all.
Representative Wood, did you have a question? No? Okay. Representative McCray.
Thank you, Mr. Chair. Mr. Portlock, I just wanted to ask you your opinion on the tier idea. And if you support it in general, do you have specific suggestions around it?
In principle, I think that the Maine medical market, as mentioned before, does a really good job of self-policing itself. Social media is a very powerful tool for us. And as a whole, the overwhelming percentage of people in this industry really want to make sure that clean product makes it to the shelves. And the impact of someone releasing product that's not clean, again, it's tested in various different stages, especially when it hits the stores. The impact that a company putting out dirty product is almost immediate, and it's huge. So if the state feels like it's necessary to further, fine people, and again, I don't think the government makes people good people. There's going to be bad people regardless of fines. Then I'm okay with a tier-based system, but on principle, I'd say that the industry can regulate itself just fine.
Thank you, Representative McCray. Any other questions from the committee? Okay, seeing none. Thank you, Mr. Portlock, for your testimony.
Thank you all.
Next up, we have William Chartier, if he is there. He's in the attendee room, or excuse me, the panelist room. So, Mr. Chartier, if you can hear us, you're up next. And I don't see him, so we will move on to Mr. Ronald Jordan.
Yes, hi, thank you. I guess I just checking for the response to broadcast. I guess I am unmuted and I'm on video and I can see myself on the computer, but it's not the same as in person. And I want to thank you, Representative Chiazzo and Senator Lucchini. I go way back for the town of Mount Desert and Hancock County, so I used to be part of your district, but I'm Ronald Jordan. I'm from Portland, Maine. I live in Portland, and I'm a medical marijuana caregiver. I operate a business with no income, basically, called Jason's Gardening, and I do it for medical purposes. Some of us have been at this for a number of years. Myself, I can provide lots of records earlier than 2009, but I would be opposed to the bills being submitted for 881 and 882 for a few reasons, but I'd like to, just basically talk in general that the program for medical marijuana, and of course, marijuana in the state of Maine, it's all within the borders of the state of Maine. And on the national stage, it's not well welcomed from the federal perspective. But Maine has an opportunity before it's to present to the country and the nation that we can lead the nation in the medical marijuana use for medical purposes. And I think that's what we ought to be focused on and stay with. While the bigger players want to develop more of the commerce of it, but you see, 2000 and if I go back to in 2012, March of 2012, I had written a letter to the legislature and presented it through Representative Denise Harlow, District 36 of Portland, and it was a letter that talked about medicine from the layman's point of view, insight into opiate addiction, and had to do a lot with medical marijuana and the application of marijuana in Maine, trying to, get something going to allow the use of marijuana to treat illnesses and people, and there was always this back and forth. And so everybody that's in the industry needs to, keep coming back to the legislature until we get it right, and that's what everybody has a job to do. And, it's all about safety for the program. And I agree with the laws and the rules that need to be developed, but let the people that know something about it develop the standards of operation and not have it, Maine is capable of doing its own work, and let those that are professional at it keep professional about it, see? And thank you very much for your time. I know it's been a long process, but let's keep at it then. Thank you.
Thank you, Mr. Jordan. Any questions from the committee? I'd
just like to, from momentarily, I'd say that I grow medical marijuana under license from the OMP, but I'm also a licensed Class 4 water distribution and water systems treatment operator. I developed the side stream injection process for ozone treatment of water systems, and at the Mount Desert Water District, where and then I came down to work for the Biddeford Saco Water Company, now a private company, and they're building a new water treatment plant. So, safety is an issue that needs to be considered, but, regulating.
Mr. Jordan, I'm sorry,
Thank you
your
very
time
much.
has expired, but thank you. We appreciate your testimony.
Right. Yeah.
Any questions from the committee for Mr. Jordan? Okay, seeing none, thank you, Mr. Jordan, for your testimony. Senator Lucchini's back. I will turn the gavel back over to him.
Thank you, Mr. Chair. It looks like we have a late registrant. We'll bring in Matthew Bayless. If Mr. Chartier can hear us, we can also try to get him in, but otherwise, this looks like the final testimony on this bill grouping. And then just so everybody knows in advance, we'll take a brief break to let people on the committee get a quick lunch. The next bill has a large number of registrants as well, so we'll just take that break. And then committee members can feel free to eat with your cameras off or whatever if you need. So, okay, Mr. Bayless is in. Welcome.
Hi, thanks for taking the time today to hear from us. My name is Matt Bayless. I'm a resident of South Portland. I've been growing medicinal cannabis for over 10 years. I've been a registered Maine caregiver for 8, and I'm actually one of the state's, I was the state's first licensed adult use cultivator. So I'm a bootstrap guy. I played by the rules, and I used my income from medical to get into adult use. And I'm here to speak in opposition to LD 1029. I've heard this idea floated through the winter that multi-state operators and larger operators wanted to open the floodgates. I'm hearing this manufactured panic about a lack of inventory in adult use, which it's patently false. I want to know where the data is coming from. I want to see numbers. I don't have corporate backing. I don't have huge investors. I got here bootstrapped all the way. The hoops I had to jump through to get into the adult use market. Now, I don't want to cut off caregivers from making an extra $500 a pound. I think that would be a great idea. But what is this going to do to the med market? And where are the med store owners testifying against this? Because what do they think is going to happen this summer to their inventory levels when adult use is outbidding med to get product into the system? I think it's knee-jerk, it's reactionary, and there's no data to back it up whatsoever. There is inventory sitting in adult use right now, sitting there, not being purchased. Why is there this manufactured panic coming up that there's a lack of inventory? There isn't. We're onboarding tier 2 and tier 3 cultivators by the week. Tier 3 cultivators produce 100 pounds every 3 weeks. Okay, I produce 15 pounds every 3 weeks. All right. So there's this panic that's not true. And it's just going to screw up both adult use market. Yes. Is it slow taking off? Sorry, we launched during a pandemic. Okay. It's going to take time. And guess what? The small and nimble people that got in and are able to operate should benefit from that. In the larger entities that are too top heavy, that have tens of millions of dollars of overhead, they're just going to have to wait their turn and get in the game. Okay, it's as simple as that. I think this is completely crazy. There's no facts backing it up whatsoever. I appreciate the 30 seconds. You know, I'll wrap it up with this. I stand in solidarity with my caregivers, sisters and brothers as well against these other LD 880. I'm sorry if I'm not getting the numbers right. These fines, ridiculous. And I'm very much in favor of going to canopy for med. I operate in both specters, and I'd be happy to answer any questions. Thank you.
Thank you, Mr. Bayless. Any questions from the committee? Representative McCray.
Thank you, Mr. Chair. Thanks, Mr. Bayless. It sounds like what you've tied a piece together that that what you're seeing is this, there's a panic about inventory, and that means we should let big companies in. Is that the link you're making?
No, ma'am. What the link I'm making is that there's a manufactured panic that there's a lack of inventory in adult use. LD 29 seeks to bring in the inventory from the medical market into adult use. So essentially letting all the licensees holders in med to now function in adult use. Well, that sets off a whole cascade of other problems. Who's testing the product? It's going to be incumbent upon who the med people can't test into metric. So how does it all work? Do adult use cultivators have to buy in a product and then test it? And then what happens to that product if it doesn't pass testing? Does it go down the garbage? Who's gonna bear that cost? You know, it's basically it's a way to try to bring more inventory into the market while debilitating med, you know, and also undercutting the small operators such as myself. Now, a huge multi-state operator that is building out a facility right now that's not going to be on board till the end of this year, they can activate their license and then start buying in all sorts of inventory from the med market and manipulating the market that way. It's unfair. And there needs to be data backing this up. Where is the data? We follow all the rules. I pay all the taxes. I pay all the licensing fees, and I don't get to take deductibles from the federal government. And now there's a bill coming along that wants to cut my legs out from underneath me. It's completely ridiculous. Where is the data? Where is the data that suggests this is necessary? This is a huge, huge thing to both markets. And I'm surprised I'm only the one. There was one other person that spoke in opposition to this. All right, and guess who spoke in favor of it? We all know who did. So it's completely unfair. It's completely unfounded. It needs to go away. And also that sunset clause on it is you know, when it was talked, when someone asked me about this on the policy side a month ago, and they said, what about a sunset day? I said, the sunset's got to be in the summer. Well, you got the sunset date in there, but it's at someone's discretion. Oh, well, maybe we'll do the sunset, maybe we won't. We'll just see. We'll see what's going on. It's ridiculous. I mean, you got two markets that are going to do great up here. All right. And here's one last analogy. I know I'm running long. We all grew up in New England driving in the snow. What happens when a car starts to slip out on you? You don't spin the wheel, stab the brakes, hit the gas. Oh, you know, you steer into the skid. And you watch what's going on. What LD 29 is someone going down a hill sideways and deciding to spin the wheel and hammer the gas. And that's how you end up in the ditch.
Thanks for clarifying. I was misunderstanding. That helps a lot. Thanks.
Thank you.
Okay. Representative Corey.
Thank you, Mr. Chair. So I'm going through the testimony here and everything for all of these bills. And I do see that you had signed up under LD 1029 to speak. I found this sort of conversation kind of really interesting. Are you going to submit written testimony so that we can re-review sort of some of the things Absolutely. That you brought to light? I appreciate that. Thank you, Mr. Bayless.
Comprehensive, trust me.
Thank you.
Any further questions? Seeing none, thank you for your testimony, Mr. Bayless.
Have a great day, everyone. Thank you.
Okay, Mr. Chartier, if you're there, we can give you another minute to try to get in. Okay, so seeing no other late signups, we will close the public hearing on these three bills, LD 881, 882, and 1029. So as we said earlier, we'll give the committee about 20 minutes to grab some food for lunch, because we're going to just go through the second block on the next section, and it's got about the same or maybe a little more people signed up to testify. So if people want to grab some lunch now, we'll try to get restarted a little bit before 12, like 11:50, 12 o'clock. And again, committee members can feel free to eat and just have their cameras off or whatever. So any questions before we take a recess? Good. Okay, we'll see everybody in a few. Okay, we'll get started in just a couple of minutes. Okay, so it's 12 o'clock. We will get started on the afternoon portion of our committee meeting. As we had announced over the weekend, we're going to do 2 blocks of bills. So this is the start of the second block. This one has 4 bills. And what I'll do is open the public hearing on all 4 bills. So that everyone knows, the first bill is LD 525, an act to allow medical and adult use marijuana stores to share a common space. And that one will be Senator Miramont. And that's followed by LD 605, an act to amend the Marijuana Legalization Act, which is Representative Peirce, as well as 613, an act to amend the adult use marijuana program rules and make other technical changes. And then the fourth bill will be an act, LD 939, an act to support Maine's medical marijuana program and ensure patient access. And that would be Representative Fluker. I would just add, if there are any co-sponsors in the attendees room, legislators, if you raise your hand, we'll give you the opportunity to speak after the sponsors, after the lead sponsors. So with that, is there a question from a bill sponsor? Yeah.
Thank you. I have to present at 12:30 in ENR. So if it was possible to make sure I can do my presentation here before 12:30, that would be wonderful. Thank you.
Sure. Yep. Okay, Senator Miramont. So we've got the bill, the public hearing's open. Welcome, Senator Miramont.
Thank you, and buongiorno, Senatore Lucchini e Rappresentante Chiaso.
Very Italian.
It's just the way I was reading your names and I went, I've got to do this. And distinguished members of the Veterans and Legal Affairs Committee. My name's Dave Miramont. I represent the people of Appleton, Camden, Creehaven, Cushing, Friendship, Hope, Isle Ho, Matinicus, Muscle Ridge Islands, North Haven, Owl's Head, Rockland, Rockport, South Thomaston, St. George, Thomaston, Union, Vinyl Haven, and Warren in Maine Senate District 12. I come before you today to present LD 525, an act to allow medical and adult use marijuana stores to share a common space. Our medical marijuana program has been a great success and a model for other states. The practitioners are professional and have become very knowledgeable about their products and how to serve their patients. As we expand the adult use program, it makes sense that those practitioners add the ability to sell products that they have developed to those who would use them for their own pleasure. The medical marijuana growers have refined their skills and can provide a product with characteristics that they know from using it with their patients. It makes sense that since they already have a location to sell from, they'd be able to use that same space for the sale and education of adult use marijuana and clients. This bill requires a separate cash register or point of sale system since there are different rules for each program. The handling and taxation of the products are defined, so I cannot see any reason to have multiple spaces. It would also be a waste of resources and energy, a doubling of security efforts, and an additional burden on these small businesses that are trying to make life better for the people they serve. Thanks for your consideration. I'm glad to answer any questions if I can.
Thank you, Senator Miramont. Any questions from the committee at this time? Seeing none, thank you for coming in today. Thanks for that Italian introduction. It's great. We have
thanks.
We have most of the Italian caucus here right now, so yeah. Thank you, Senator. Okay, next we'll open up turn to the bill sponsor of LD 605 and 613, Representative Peirce. Welcome.
Representative Peirce, we can't hear you for some reason.
Still can't. It says you're not muted, but. I think I'm hearing a little something there.
Can you hear me now?
Yep. Gotcha.
Okay. Who knows?
Yep.
No idea what was
That's
going on.
what happens.
I'm not going to attempt Italian. I'll just say that right now. So. Senator Lucchini, Representative Chiazzo, and members of the Veteran and Legal Affairs Committee. I'm Representative Teresa Peirce, representing House District 44, which is the majority of Falmouth. I'm here today to present LD 605 and LD 613, an act to amend 605, an act to amend the Marijuana Legalization Act. I introduce these bills on behalf of the Office of Marijuana Policy. We are bringing you proposed language, which is attached to this testimony and would do the following. It amends the definition of marijuana trim, mother plant, and seedling. It expands the permitted uses of the Adult Use Public Health and Safety Fund. It exempts sample collect licensees from the requirement to register with the state tax assessor to collect and remit sales tax. It removes the prohibition on the use of the same building to conduct sales of adult use marijuana and marijuana for medical use. And finally, it repeals the sunset on licensee self-sampling for the purpose of mandatory testing. I appreciate your consideration and look forward to working in the committee on this proposal. I'd be happy to answer any questions that are general, but I would defer to the staff who are here today. Thank you so much for this opportunity. I'm always happy to be in front of VLA around this topic. Obviously, having served as the House Chair for the Marijuana Legalization Committee, working with members on this committee as well on that, I always appreciate having a conversation around this industry and this market, especially as it gets off the ground. And I just want to take the opportunity to thank the Office of Marijuana Policy for the work that it's done in the last 2.5 years. It's been an amazing amount of energy and excitement around this, and a pandemic was thrown into it among a lot of other things. So I look forward to hearing the comments that surround this bill and others as we work together this afternoon. Thanks so much.
Great, thank you. Any questions by the committee for Representative Peirce? Seeing none, thank you for your testimony. And now we will turn it over to Representative Pluker, who's going to present LD 939, an act to support Maine's medical marijuana program and ensure patient access. Welcome.
Thank you very much, Senator Lucchini, Representative Chiazzo, the entire committee. As Senator Lucchini said, I'm here to present LD 939, act to support Maine's medical marijuana program. I'm Bill Pluker. I represent House District 95, Warren, Hope, Appleton, and part of Union. Our medical marijuana program has been running for decades, treating the sick and dying and supporting the farmers of Maine. It's a tremendously successful program. As I'm sure you've seen, total revenues from marijuana in Maine are more than potatoes and blueberries combined. Thousands of patients have been treated. This is a program that deserves the unreserved support of the legislature. As a small farmer myself, I understand the work, the risk, and the hope behind any act of agricultural entrepreneurship. I've seen how the medical growers in my district have managed to succeed despite inhospitable regulatory system. As a multi-part bill, it creates an overall more hospitable regulatory framework for our small business owners and farmers so that we can see this industry continue its success in the state. And I'm going to go through the changes that it makes, just kind of going through the numbers as we see them in a summary if you want to follow along. Number one speaks directly to the fact that these are small scale family growers who would like to have the help of their children, as any small farmer would. It allows family members down to the age of 18 to be able to help the family business. In part two there, you see this allows farmers who want to be farmers and sell their whole crop to someone else for retail sales, meaning we're allowing fully to sell wholesale so that you don't have to handle the retail yourself. This means that the farmers don't have to spend their time trying to sell retail as well as the wholesale. We've heard a lot of that kind of testimony this morning on the earlier bills. This change will not create a situation where patients don't have access, but will actually allow us to increase supply for these patients as the farmers are able to specialize in the work they do best. Number three, in these times of COVID, we have seen how digital transactions are so important to keeping the markets moving. This is a simple change that allows the initial purchase to be made with a digital copy of a written certification, and then followed by verification of the hard copy at the point of transaction. Once again, a small tweak to the rules that allows these farmers to do business. This allows number four, allows a worker to change employers within the industry and not have to get a new background check each time within the calendar year. So this allows a certain amount of freedom for the workers to leave a bad situation, or if they run out of work at one site, to move to another when the work is done without having to get another background check. We expect the workers to get a background check annually, and this does nothing to change that expectation. Number five, not all plants are made the same. And we've already been talking a lot about plant size this morning. Some varieties grow large canopies and are large plants, others are smaller plants. For those of you accustomed to gardening, you could think of growing a fingerling potato versus russets. If you're regulated by the plants, you'll always grow the variety that turns the most weight. But if you can grow more plants per square foot, you might just grow the more delicious, those smaller fingerlings. This change allows the farmers to grow smaller plants of different varieties rather than having to focus on always growing the ones that return the most product per plant. The provision adds a fee structure for the clarity of the producer to the canopy system of growing and licensing. Number six, we're seeing these producers growing for both medical and adult use markets, as we heard Senator Miramont refer to. This makes sense as the products are so similar and the growth of these plants is so similar. Fundamentally, it is the regulatory framework that is different between the adult use and the medical, as you well know. We should allow these businesses to market all of their products at the same time. Having separate advertising for the same business just doesn't make good business sense. Number seven, currently we say that marketing on mobile devices can only happen if the grower develops an app and the consumer uses that app. Growers should be able to advertise their businesses just as any other business on the internet. Forcing the costly development of apps and trying to have consumers download that app before an advertising happens just doesn't make economic sense. This is a way of trying to get regulation out of the way for the small business person. Number eight, maintaining records for 7 years is just burdensome. The IRS doesn't require records to be kept that long. Organic certified growers don't have to keep their records that long. Even clean elections candidates spending tax dollars don't have to keep their records that long. And it's time to make a sensible timetable that works for these businesses. And finally, number nine, this section allows growers to not have to hire third-party auditors every year. They're keeping their records and are open to inspection from the state at any time. They submit all of their applications and licensing materials every year. It does not make sense that they must also hire another round of inspections on their own dime annually. Just to wrap up, we need to get out of the way so these small businesses can do their job. They're making money in a difficult environment in a state that needs small entrepreneurs and can operate in a rural environment. These folks are growing from their farms and selling out of their homes. This is medicine that is helping sick people feel better and heal. They're providing a service to the community, fuel for our economy in hard times, and healing our sick. It's time that the state government treats them as the hardworking small business people that they are. Thank you very much, committee.
Thank you, Representative Pfluger. Representative Court.
Thank you, Mr. Chair. So I'm looking in here, with regard to advertisement and being able to cross-advertise medical and recreational marijuana. We also have a bill in front of us that would allow co-location of stores and everything. I sat on the committee a while ago that had rewritten the adult use marijuana law. One concern I have, and when I've been talking to caregivers, recently, they really all have mixed feelings on this. They don't all have the same feeling. They feel more and more that when they put themselves on the same track as the adult use market, they become concerned that they could lose, the medical program. Do you feel like that moves us in the direction of doing that if, we start allowing the products to be co-located and advertised the same, that, really we're talking about medicine, but then we're also talking about a recreational substance here in the same, do you know what I mean, breath, which.
Yeah, I think that's a very valid conversation and very valid debate to have. I think if we're going to keep the regulatory environment separate, as we've been talking about this morning, if we're really going to have a medical program versus an adult use program, then making sure that we're not moving, I think that's more important at the end of the day, is to have clear, separate regulatory environments. If they are moving together, as some moves we've seen, within OMP, then I think opening up the regulatory environment so that people can really operate in both a little bit more freely makes sense.
Okay, any other questions? Seeing none, thank you, Representative.
Thank you very much.
Yep. Okay, so those are the bill sponsors for the 4 bills. I am not seeing any co-sponsors in the room. So now we'll turn to the public comment portion. Again, I'll just remind everybody that we are limited to 3 minutes, and if you can keep your remarks to the bills before us, that would be great. And also, when you're being called upon, if you can remember to state your name, your place of residence, and the organization you represent, if any. That'd be helpful for us to know who you are. So we're going to begin by going through, with Mark Barnett. He'll be followed by Jennifer Bergeron and Samantha Brown. Welcome, Mr. Barnett. Yep.
Nothing breaks through the wind I'm getting here while I'm testifying. So again, good afternoon. My name is Mark Barnett, resident of Auburn, medical caregiver and owner of a retail caregiver store in Portland, executive chair of the Maine Craft Cannabis Association. There's a lot of bills on this one as well. I just wanted to speak very quickly. I had registered in opposition to the 2 concept bills. That does not necessarily mean that our association is opposed to the contents of those bills, but because there were no contents for public review, we simply don't support that kind of legislative work. So I wanted to spend most of my time on LD 939, which I believe ought to pass. A number of policy items in the bill that can't necessarily get to, but I think Representative Pluker did a really great job walking through those, so thank you for that. This bill contains common sense fixes to Maine's medical program, closes oversights in statute, lowers caregivers' liabilities for operating. Marijuana is still federally illegal, can bring unjust legal complications. Mainers have repeatedly voted against the unjust criminalization of cannabis. It seems right now that the OMP is trying to create technical rules so burdensome that the majority of caregivers would be out of compliance on day 1. And there's a threat that caregivers out of compliance could be referred to the DEA. Therefore, I think the legislature should act to prevent this, and LD 939 is an important start. The largest problem is the requirement for caregivers to sell 25% of their crop directly to patients. There are several issues with this. Directly conflicts with municipal ordinances that actually prohibit caregiver retail without a second municipal retail license, which in some cases isn't even possible. It's also very expensive. It forces farmers to own a store or to receive patients in their home or deliver, which the Office of Marijuana Policy is aiming to make significantly more expensive and difficult. And as the sponsor referred to, it hinders caregivers from specializing in what they do best, which is cultivate excellent cannabis for use, for therapeutic use. Medical program functions best when caregivers can differentiate, and the 25% restriction discourages that. I'd note that all of the participants in both the adult use and the medical side of the program can specialize, so we shouldn't be putting this limit on the most important part of the supply chain. I also wanted to highlight that the OMP of today or the future could use this gap to sanction, fine, and disqualify caregivers, potentially exposing them to unwarranted federal legal problems for not being able to retail product. Thank you, Mr. Chair. And I would just say personally, OMP inspectors have told registrants that even doing business with caregivers who don't comply with the 25% might be working with criminals. So of course, we're a little bit concerned about that. Just real quickly on the canopy question, this was a fix that I think is totally uncontroversial. I believe it was the intent of the legislature at the beginning to have a similar fee structure for both of these options. And I think that we should honor that and make this minor fix. And then again, the other items in this bill do reflect just common sense revisions to an overly restrictive regulatory regime. You've gotten a lot of message from the administration that we need to crack down. I think in reality, it's quite the opposite. And I think you're going to hear more of that today. Thank you.
Great. Thank you, Mr. Barnett. Any questions from the committee at this time? Seeing none. Thank you. Okay, next up, we have Jennifer Bergeron, followed by Samantha Brown and then William Chartier. Welcome. Where'd you go? Oh, there you are. Yeah. Oh, Jennifer, we can't hear you at the moment. Still nothing for it. Doesn't say you're muted, ironically. If you'd like, we can come back to you if we can. Maybe going in and out. I don't know. All right. Well, we can try. If you want, you can just try to re-register back in, and then we'll take you whenever you come in. So sorry about that. Okay, so we'll move to Samantha Brown, if possible. Yeah, welcome.
Good afternoon. I'm Samantha Brown from South Berwick. I testify as a parent of a child patient with pharmaceutical-resistant catastrophic seizure condition. I support access to their caregivers. I support small businesses. And on LD 939, I support in its entirety. I want to highlight the section that will allow for unlimited transfer from caregivers to another. There's no justification on the current limit. It's arbitrary and should be repealed to allow the potential for caregivers to succeed. LD 525, I oppose the bill. I don't oppose the idea itself, but I have no reason to doubt that it's an attempt for future attempts to combine the medical and adult use programs until we can actually repeal or put protective measures to protect small businesses and patient access. My goal is to preserve the medical program, and I see this as a potential threat to allow special interest departments to align the two programs. And I'm confused on the way the bills are supposed to be heard today. I'm kind of stuck on LD 605. I think that may have been this morning, but I just want to reiterate and be on record that these bills that are concept bills that when the language is brought at the moment of the public hearing is absolutely despicable. How are we supposed to work like this? No one knows what it says. No one's here to say anything about it, and I completely disagree with that. And this concludes my testimony.
Thank you, Ms. Brown. Any questions from the committee at this time? Representative Corey.
Thank you, Mr. Chair. Thank you for being here today, Ms. Brown. I definitely, I think, agree with you on 525. You know, I get worried that the medical program and the adult use program get too homogenized, and then we could end up losing, you know, the medical program to the adult use program. I also had a concern, though, within the bill that you support, which would be LD 939, and I brought this up to the bill sponsor, you know, with regard to advertising adult use and medical products in the same advertisements and everything else, which definitely kind of aligns, you know, the two programs and, you know, doesn't separate, you know, what's medicine for what's, you know, for recreational use. Do you support that section of that bill, or would you still like to keep those programs separate?
I haven't really given that specific subject my full thought. If we're gonna have to start regulating things on that, and maybe it might be an idea to keep it separate. But like I said, I'm kind of neutral at this moment in time.
Any further questions at this time? All right, seeing none, thank you, Ms. Brown. So, Ms. Bergeron, can you hear us, or can we
I
hear
hear
you?
you. Can you hear me?
Yeah, we can now. You're good.
Okay, excellent.
Yeah.
Sorry, so I will introduce myself and say good morning to you all. That was a little distracting. I'm Jennifer Bergeron. I'm a caregiver with a grow in Waterville. I live in Winslow. On 525, 605, 613, I oppose these bills. And would also like to say, I don't know how these things come in with no language, and yet today's the day we're giving testimony. That shouldn't be allowed. I wish that somebody would introduce a bill saying that that's not allowed in the future. But my reason for opposing these bills is before adult use was launched, we, as the medical program, were assured repeatedly, this will not affect medical, this will not affect medical. And it was the drumbeat, you know, this will not affect medical. That was the mantra they kept saying. So now it seems as though we're trying to merge medical and adult use because the department says we need to align the programs. Well, every time we try and align the programs, it's to the deficit of medical, it's to detriment of medical. It doesn't ever seem to help us. When we're aligning, there's never a, oh, hey, medical, you get this extra thing. No, it's always, oh, we have to align the program, so we need to do something worse for your program. So I just think the more we try and align them, the more we try and have building shared space, et cetera, the worse it is for us. We get hit with very bad results. So anyway, and then I'm going to speak in favor of 939. And Mr. Representative Corey had asked about the advertising. I do agree that those should be separate. The only part where I think that maybe advertising for adult use and medical would be appropriate would be perhaps for processors who do process for both medical and adult use. And I am not opposed to those being, for processors being able to do that, or testing facilities perhaps being able to do that. But as far as medical and adult use, when it comes to caregivers or caregiver retail stores or any of that, I don't think that there should be any advertising shared. Also on 939, as I said, I am for this bill, but I do believe that 1,500 square feet would be more appropriate than the 500 square feet canopy space. And it looks like my time is pretty much up, so I don't have time to get into anything else yet.
Thank you, Ms. Bergeron. And yeah, I'll just add, I'm not a fan of concept drafts either. Although I will say if for people who want to stay up to date on our stuff when sponsors eventually give us language, we do send that to the interested parties list, but I don't it's not my favorite thing in the world either. So
it seems like we should have at least a week to review, you know, that the language should come out before they're added to public testimony.
Yeah, I mean, yeah, it was, I will say it was sent out a while back, or a few days ago, but it's just never the best process. So Representative Corey.
Thank you, Mr. Chair. So thank you for being here today, Mrs. Bergeron. So just to be clear, that what you're saying for advertising is that for advertising within the industry, like professional services in the industry, you think it's okay for that to be, and I would tend to agree with you on that, but advertising, medicine and recreational use of in the same add that sense of confusing message about the two programs.
Yes, so that's exactly what I mean is, if somebody was advertising that they're a processor, as far as like a testing facility or somebody who processes trim into concentrate or something, then that would be appropriate to have in the same signage. But I just don't believe anything to do with the sale of medicine should be in the same kind of signage as the sale of a retail product for adult use.
Thank you.
Thank you, Representative Corey. Any other questions for Ms. Bergeron? All right, seeing none, thank you, Ms. Bergeron, for your testimony. Up next, we have Kate Dufour, and she'll be followed by Melina Dumas. So, Ms. Dufour, when you are ready, the floor is yours.
Great. Good afternoon, members of the Veteran and Legal Affairs Committee. My name is Kate Dufour, and I'm here on behalf of the Maine Municipal Association to provide testimony on elements of testimony in opposition on elements of LD 525, 605, and 939 that strike municipal officials as circumventing municipal local authority with respect to regulation. And I'll just point to the two issues that we have flagged as of concern. In LD 525 and 605, we're concerned that authorizing common space sales of both medical and adult use marijuana and related products could result in those activities taking place in a community that has not opted to allow adult use retail sales. And to the extent that the legislature believes this proposal has merit, we ask that you do two things. The first is that if the use of shared spaces is authorized, it should be only authorized in communities that have adopted or opted to allow those shared spaces. The second is to require that an individual who is providing both marijuana adult use as well as medical to have both licenses. So local opt-in and fully authorized to provide both services. With respect to LD 939, we're concerned that the wholesale transfer of marijuana from a caregiver to another caregiver or a dispensary will result in the establishment of default caregiver cultivation facilities. And to the extent that the legislature believes that caregivers should be providing cultivation services, again, we ask that the controls and the options that are provided to municipalities to opt in to allowing these operations within their municipal boundaries are also extended with this case. So to the extent, basically asking that you protect our ability to decide how best to allow and regulate this industry within our municipal boundaries. And I thank you for your time and consideration.
Thank you, Ms. Dufour. Any questions from the committee? Okay, seeing none, thank you, Ms. Dufour. If you could please, for certainly in my community has passed a moratorium on recreational use. So I would be curious if there is any kind of language or what type of concerns the MMA would have. If you could have something to me or to us, hopefully before the work session, that would be great.
We'll try.
Thank you.
Thank you.
Up next, we have Melina Dumas, and she will be followed by Greg Ellis. So, Ms. Dumas, when you are ready, you have the floor.
Yes, thank you. Good afternoon, Representative Chiazzo and members of the Committee on Veterans Legal Affairs. My name is Melina Dumas. I'm an attorney with the law firm Drummond Woodsum, and I'm here today on behalf of Maine Organic Therapy, Remedy Compassion, and Curaleaf Maine. I'm using my time in this block to testify in support of LD 525 and LD 605. We generally support LD 605, and time permitting, I'll provide some specific comments on that at the end, in particular in regards to support for the sample collector amendments. So we support the co-location of medical and adult use marijuana stores, and we do believe that LD 525 provides the best model to move this forward at this time. As more adult use marijuana businesses come online, allowing medical and adult use marijuana sales to be in the same location will allow those medical marijuana stores to continue to thrive. Rather than shutting down a caregiver retail store or a registered dispensary to transition to adult use marijuana sales, a business could locate these businesses in the same space. Allowing sales to take place in the same premise reduces the costs and complications associated with either finding a new property or reconfiguring spaces in the building to make that work. While we would prefer to have caregiver retail stores and dispensaries operate out of the same premise as an adult use marijuana store, we would also support the model of medical and adult use sales taking place in the same building, as outlined in LD 605 as an alternative if needed. If the committee does support passage of LD 525, however, we do suggest a couple of amendments. As currently drafted, the bill says a marijuana store licensee that is also a registered caregiver or dispensary may co-locate, may sell both medical and adult use marijuana in the same premise with the two separate points of sale. But so that language, a marijuana store licensee that is also a registered caregiver or dispensary, seems to indicate that the entity that runs the registered dispensary or is listed on the caregiver's card must be the same entity as the adult use marijuana license holder. Given the different restrictions on who can run and own businesses in the medical marijuana program and in the adult use marijuana program, the bill should be amended for the sake of clarity and implementation. And in amending the bill, the legislature could look to how plant transfers currently work between the medical marijuana program and the adult use marijuana program. A licensed adult use marijuana cultivation facility that has an owner or principal who is a registered caregiver or director or officer of a registered dispensary is authorized to purchase plants from other registered caregivers or dispensaries. So in the context of this bill, an adult use marijuana store licensee should be able to co-locate with a caregiver retail store or dispensary that shares a common owner or principal if the intent behind LD 525 is to require these businesses to be affiliated. We do agree with Maine Municipal Association's testimony that amendments could be made to make it clear that medical and adult use marijuana stores can only co-locate if the municipality has opted in for both uses and the businesses have required the necessary state and local approvals. And then again, I would just say that sample collectors, given the size of our state and the limited number of testing facilities and the dearth of sample collectors currently, it's really important to allow marijuana establishments to engage in self-sampling moving forward. So we support the repeal of that provision that has the expiration date in October. Thank you very much. I'd be happy to answer any questions.
Thank you, Ms. Dumas. Any questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Up next, we have Mr. Grant Ellis, and he will be followed by Ryan Ellis. So, Mr. Ellis, the floor is yours when you are ready, sir.
Thank you, Mr. Chair and members of the committee. Nice to see you all again. I hope you all enjoyed your lunch break. And thank you very much for your consideration of my testimony today. I'm only going to be testifying on two bills today, as there are so many other informed people who will be providing testimony on the others. I'd like to testify in opposition to LD 525, and I think a lot of the points that I was going to make have been brought up by members of the committee and those who have testified before me. But primarily, keeping the medical program separate from the adult use program is what allows the medical program to provide low-cost access for patients like myself who are on Social Security disability or otherwise on a fixed income. And so ensuring those two programs stay separate allows for that medical program to have its own set of rules that are more focused on holistic patient care, accessible medicine, and low cost than commercial profit. And there's a litmus test that I think can be used as to whether a proposal is going to end up benefiting patients or end up benefiting commercial interests. And that litmus test is obviously why we have public comment sessions like this to parse out which bills are supported by sort of patients and which bills are supported by commercial interests. So I oppose LD 525 for that reason and encourage that the committee does as well. But I do strongly support LD 939 for the reasons enumerated previously, which is that bill, if adopted, would allow the medical program to flourish, and by allowing the medical program to flourish and operate in a more seamless manner, access for patients like myself is what it ends up as the end result. I think the committee today, early in the morning and this afternoon, has heard from a number of caregivers who oftentimes are doing this at breaking even and sometimes maybe even losing money, because they're not operating for profit. They're operating to provide accessible medicine to people who oftentimes have cancer or who cannot leave their home or who are the most vulnerable. So anything that can be done to reduce the regulatory oversight of that medical cannabis or the burdens on those providing that medicine at cost will help them provide that medication to more patients. And that's why I urge the committee to vote ought to pass on LD 939. And I appreciate your time and the opportunity to spend the day with you today.
Thank you, Grant. Any questions from the committee? Seeing none, thank you, Grant. We appreciate you spending some time with us today as well. Next up, we have Mr. Ryan Ellis, and he will be followed by Mark Ferraro. Mr. Ellis, when you're ready, sir.
I think I'm ready. Can you see me? Are we
Yes,
good?
sir. We can see you and hear you. You're good to go.
All right. Thank you for hearing me again on this day, second time. I am mostly just I'm actually exclusively speaking in support of 939. It really includes some much needed just fixes that over the years people within the industry have reached a level of consensus on, to being able to do their jobs better, to be able to serve patients better. It's been spoken to already, the fact that caregivers are required to sell 25% directly to customers. That's a weird rule ultimately, I think, that was put in place to keep caregivers who are more focused on production down. There is no rule that exists on the retail side. You can be a retailer and not grow any cannabis and still, move forward, or you can be a manufacturer and not produce any cannabis or sell any to patients directly. So that needs to be, 100% wholesale needs to be allowed, in my opinion. Let's see. Oh yeah, I'm a resident of Freeport. I also have a cannabis retail store in Augusta, Maine. I also produce my own cannabis sometimes. I also buy some in. So let's see here. Yeah, 939 needs to pass. There are a lot of fixes in there. The canopy fixes in there as well. Someone spoke earlier to, wishing the canopy was increased to more. I think that the intention of this is really to just bring things up to a level that is reasonable, to show that canopy can work, can be effective in, in being a way that people are licensed. And I could see that as more people adopt this, there would be more push towards, a larger canopy in the future. I think that's about it. Support 939. Thank you.
Thank you, Mr. Ellis. Any Representative Corey?
Thank you, Mr. Chair. Thank you for being here today, Mr. Ellis. So, I mean, I've been kind of a little bit intrigued by the whole canopy thing with regard to growing or giving, caregivers a system to grow within. We had a bill earlier this year that looked at increasing the amount of canopy space. I don't want to use the word tiering, but I'm going to, because we use that in the adult market. And I think these two markets have to remain sort of very separate. But would you, think about actually creating licensing tiers within the medical marijuana program that would allow, a caregiver to actually get up to, a larger, grow if they would like? It would just be, a separate licensing requirement, maybe a separate municipal requirement, but it would actually allow growth within an industry. I imagine that, at 30 plants or 500 square feet of canopy space, you're limited in just how big you can eventually get. Would you be interested in tiering?
I have no opposition to that particularly. I think that perhaps there should be some sort of check valve on how quickly people can move through tiers, because if you can't do something well on a small scale, you'll probably be terrible at it on a larger scale. Some sort of, just checks and balances for the expertise of the professional. I came from the automotive background where, they don't let you do really crazy stuff until you've proven over and over again that you can handle, smaller tasks without dropping the ball. But I do really think that a tiered approach is important to support the growth of those who want to be empowered to grow.
Thank you.
No problem.
Any other questions for Mr. Ellis? See none. Thank you, sir. We appreciate your time today.
Thank you.
Up next, we have Mark Ferraro. He'll be followed by Donald Gardner and then Director Gunderson. So, Mr. Ferraro, when you are ready. You are muted, sir. Just a reminder. Sorry.
There we go.
Perfect.
Thank you for taking the time again today. Hope you had a nice lunch. I'm a store owner. I live in Nobleboro, run a store in Daramuscata. I'm, speaking today in support of 939, which I think represents a number of positive changes in the medical program. I really feel these are a number of common sense measures that improve access, strengthen the supply chain, and correct a technical fix, which is in regards to the canopy plant count issue. As I said, I run this store in Daramuscata, and I see caregivers all the time who are pretty frustrated by the fact that they have no outlet for this 25% of product that they are producing. Municipal rule limits the number of stores. Most farmers are not vertically integrated, so they do not have a storefront that they can simply put their tomatoes at, as they would with a local farm stand, say. So they have no outlet, and they run this risk of essentially growing too much and running afoul of a program simply for lack of a means of selling it. I think establishing 100% wholesale remedies this. I think artificial harvest limits constrict farmers' ability to effectively plan for their harvest, and place, really put them in potential violation. Moving on, I think that we do need to move to fix the canopy issue. Currently, growers are sometimes paying twice. The OMP has recognized this, has literally said, we understand you guys are paying double. We know this is wrong. It needs to be fixed statutorily. I don't think it's a big change at all. And I think that's a simple change to allow farmers to choose and pay an equivalent fee. Telemedicine issue, really, really big issue for us. Many patients, most of my patients get their card through telemedicine, especially during COVID times. When they get that card, they're often issued a temporary, or what is referred to as an electronic version of that card from the healthcare provider directly. And that is not accepted currently under program rules. And many times people are waiting 8 to 10 days to get access to their medicine. And these folks may be a renewal. So these patients suddenly have a bottleneck which should not exist. Allowing for acceptance of digital cards will absolutely improve patient access to a great degree. And I think it's a simple change that we can do. Electronic versions of signatures are valid for mortgages. I think they could be valid to get one's medicine. And lastly, in regards to program participation age, anyone can become a program participant at 18 years of age and enjoy full access to the program. The overwhelming majority of caregivers are family businesses, thank you, employing just 2 to 5 people. Actually, it's important to remember that of the 3,000 plus caregivers, only 75 employ 20 or more. So we're actually looking at micro businesses who have a very small labor pool, mostly immediate family. I think we should absolutely allow people who are 18 years of age to have access to processed flowers, inherently not a dangerous substance, and help their family businesses along. Thank you for your time. Best of luck this afternoon.
Thank you, Mr. Ferrero. Any questions from the committee? Seeing none, thank you for your time today, sir. Up next, we have Donald Gardner. He'll be followed by Director Gunderson, and I will bring in Ronald Jordan for the third person. So, Mr. Gardner, when you are ready, sir, you can begin.
All right. Can everybody hear me all right?
We can hear you great, yes.
All right. Good afternoon. Thank you for seeing me again, representatives and members of the VLA. I appreciate all your time. Again, my name is Donald Gardner of Washington, Maine. I operate Stonehouse Gardner independently. I come before you in support of LD 939 specifically. And I can really, really speak from the heart on this one, because back in 2018, when we became allowed to wholesale to other caregivers, that's really where my whole business turned around. Because trying to find individual patients is an absolute nightmare. And like many before me have said, when you have this 75-25 thing, it just doesn't make any sense. Like, we need to be able to have the option to wholesale all of our product to the stores, especially people like me who are seasonal. We want to be able to move all of our product at once, just get rid of it. We don't want to deal with it. It would make things exponentially easier. Otherwise, we have to open up a storefront. And as before with LD 881 or 882, there's all these limitations on opening storefronts. And so it doesn't make any sense why we wouldn't be able to wholesale everything to the stores. It's the reason my business is successful. It's the reason I'm even here to begin with. In 2017, I was ready to drop out. I was done with the medical program. I was done. I was going back into the food and beverage industry. It wasn't where I wanted to go. I was depressed. It was horrible. And all of a sudden this passed, and it enabled me to wholesale my product, or at least 75%. But that itself is a roadblock. You know, you have all these proposals that are coming forth from OMP, all these new changes where I still have issues with the old one, with the old rules, whereas LD 939 will correct it. That will completely correct it. That will make everything exponentially easier. I really don't know how else to say it. I mean, it's like, it just closes this our arbitrary requirement. Thank you for the 30 seconds, Representative Chiazzo. Yeah, I really just don't know how to say it. It's apples to apples. It doesn't make any sense. Like, if the guy who sells tomatoes, like, why can't he, like, he sells 100% of his crop. Like, what if he had to sell 25% before it rotted? It just doesn't make any sense. So thank you for your time. Yeah, I support LD 939. Thank you.
Thank you, Mr. Gardner. Any questions from the committee for Mr. Gardner? All right, seeing none, thank you, sir. We appreciate your time this afternoon.
Of course, thank you.
Next up, we have Director Gunderson. He'll be followed by Ronald Jordan and Dawson Julia. Director Gunderson, at your leisure, sir.
I get on mute there, sorry. Good to see everybody again. Chairman Chiazzo, members of VLA committee. Want to use the first 20 seconds to clarify some of what we've heard today as far as combining the two programs. The Office of Marijuana Policy has been entirely transparent and clear that we have no intentions to do so. We understand the difference between a consumer and a patient. And when we hear the word alignment, a lot of what we're talking about right now have been legislative directives from 2018 to align some of the public health and safety policies that were put into place that are similar to the adult use, whether you're talking about inventory tracking, local authorization, packaging and labeling, and security requirements are all public law now, and we're in the process of aligning those, or I shouldn't even say aligning those, implementing those. But we can start with Senator Miramont's bill, co-location. Last session, we testified more or less opposed to it with two main concerns. One, we were making a substantive change before we had even launched the adult use program. And two, we had concerns about potentially having product in one retail store with some of the product that's tracked via the state's inventory tracking system and some that was not. We have since launched. We have the intentions of implementing the required inventory tracking system. So we're really neutral on this because we understand that registrants and licensees fall on both ends of this. But if it's something the legislature wanted to do, we can most certainly do it. As far as our bill, I can apologize for the concept draft. We did send the language out about a week ago. This was originally in our department bill. which was combined with the transfer of flower and trim bill, which we heard earlier this morning, which was a comprehensive bill that was passed with, I believe, a majority vote from the VLA committee last session. You can tell by the last piece of testimony they got from Mr. Bayless, the reason we stripped out the transfer of flower and trim is because it's, again, we have launched. It's hard to understand the impacts of that proposal on either program. We wanted to be able to have a conversation about that bill on its merits, while having the other portion of the bill that had unanimous agreement on move forward, mostly having to do with some technical changes that were in the bill last session. Also, additionally, opening up the Public Health and Safety Fund and broadening it for a public health and behavioral health programs, and also to incorporate the local municipalities' participation in the law enforcement training. And then finally, the omnibus bill. There is a lot of stuff that we certainly agree with that would be helpful. The department is open to having family members 18 to 21 if that's the direction that the legislature wanted to go. We're fine with reducing records retention, but going to 2 years, we have 3,000 registrants and 10 field investigators. It is just impossible to be able to check in with all of those registrants within 2 years, but we would be willing and able to have a conversation about what was appropriate. And then finally, as far as the wholesaling, the department did support this measure in the past. We still do so as long as the committee has considered certain things like brought up by Kate Dufour and MMA. And then also it's been flagged by the AG's office that there would need to be some other technical changes specific to the statutory purpose of registered caregivers, which is for the purpose of assisting a qualifying patient with the patient's medical use of marijuana. And as soon as you break up vertical integration, where you're talking about there's growers, manufacturers, and retail stores, there would just need to be other considerations if that change was to happen. But again, we're supportive of that as well. A lot of other stuff, but we could talk about it at the work session.
Thank you, Director Gunderson. Any questions for the director, either now or to prepare for the work session? Representative Wood.
Thank you, Mr. Chair. Mr. Gunderson, obviously there's a lot going on with marijuana, and I'm new and I'm trying to get it all. Just a question about track and trace, and somebody in their testimony also referred to it as seed to sale. I'm assuming that's the same thing, just a different verbiage.
Yep. So, I'm sorry.
And does it already exist? Because I thought I heard somebody say it already exists, but then I think I hear a lot about we are looking towards putting it in place.
Yeah, so seed to sale, inventory tracking, track and trace are all the same tool in which the department uses in, well, it's statutorily required for both programs. And it has a lot of value to it. And that's the reason why you see it in law on the adult use side. And that's the reason you saw the HHS and the HHS subcommittee put it into law back in 2018 for the medical program. First and foremost, inventory tracking or seed to sale is the main tool in which we can use to prove that there's no diversion or inversion within the program, to ensure that the product stays within the program and ends up in the hands of patients. Right now, we're unable to do so. It also comes with the added benefits, again, of those public health considerations, which both the MLI committee and the HHS committee took very seriously when they recrafted both the adult use and the medical. Again, those products that might pose up public health risks. It's a real thing. We saw it with the vitamin E in vaping a year and a half ago, whether if the product ends up on the store shelves that poses that public risk, the Office of Marijuana Policy can track back to where that contamination was and find all of those products across the state and ensure they don't end up in the hands of patients. And again, it also serves other purposes as far as to help ensure compliance with the program. And the one that's often overlooked is the massive amount of data that the state can gather from the inventory tracking system. We were directed by the legislature to collect that data and put together a program to better understand the impact of these programs on our state. And we're in the process of doing that with a data lake and a data warehouse, where we take data from our licensing systems, we take data from our compliance systems, we take data from the inventory tracking systems, and we're working with numerous state agencies across the state to get marijuana-specific public health and safety data. which will allow us to answer some incredibly tough questions and really make data-driven decisions. But that would unfortunately be, I don't want to say impossible, but we wouldn't be able to really get the answers we were looking for without the important data that we are able to get from the inventory tracking system.
Thank you.
You're welcome.
Thank you, Representative Wood. Representative McCrate. Actually, before you go, Representative McCrate, just a reminder, the chat function is not used for an exchange of information. So please refer from using the chat as a means of communicating. Thank you. Representative McCrate, you have a question?
Yeah, thanks, Mr. Chair. Director Gunderson, whether now or for the work session, I had a couple questions about your position on some of the factors in 939. The advertising piece. Interesting testimony. I think that it might be appropriate for processors, testers, but not for others. And I'm just curious about that, as well as the digital image of the written certification, those kinds of things.
Well, I mean, so as the digital one, the way that we read it really has no practical impact on how it would actually function and work. And as for the advertising piece, there is some legitimate concern here. The prohibition on the advertising as it relates to both medical and adult use is only written into the medical law. So it would be the register on the medical side that would be in violation of that. We'd be totally fine with removing that piece.
Thank you.
But we'll certainly provide the testimony that's submitted goes into detail on all of these provisions, and I'm more than happy to speak in detail of any one of them at the work session.
Thank you.
Thank you, Representative McCrate. Any other questions for Director Gunderson? All right, seeing none, thank you, Director. We'll see you at the work session.
Thank you.
Next up, we have Ronald Jordan. He'll be followed by Dawson Julia and Hannah King. If she is in here, I will bring her in. So, Mr. Jordan, you have the floor, sir, when you're ready.
Yeah. So I just checking again, check. I don't know if I'm live yet, I guess.
We can hear you and we can see you. You're good
All
to
right,
go.
thank you. And thank you, Director Gunderson, for your hard work at the policy department. And one of my biggest issues, I think, with the everything is my fear and probability and statistically about
Mr. Jordan,
yes?
my apologies. I don't mean to stop you. Can you just please introduce yourself again?
Yes, hi,
where
yes,
you are,
I'm
where you're
sorry.
from, and
I'm
who-
Ronald Jordan. I'm from Portland, Maine. I'm a registered marijuana caregiver, and I'm a grower, and I grow marijuana for medical purposes, and I'm interested in the medical side of it necessarily, and keeping the medical community actively engaged with their patients and providing patient access and in a medical setting and everything. And so my comments to the program, and I understand that it's by statute, the data management, seed to sale collection of the data. And I don't disagree with that need to trace product through sales and as it gets modified. And let me say that part of the separation of the difference is you grow a flower that's clean and pure and product free from contamination, or it can be sort of graded that way and judged that way, but some of that opportunity from cracking the seed into putting it into the bud that's pure is proprietary in a way, because the grower has specific ways they produce that and everything. And I'm concerned about a little bit about the process that it gets from seed to the flower that gets to the market. Now, the other part of that is when you turn that flower into something and you add to it, whether you extract the product and a lot of these vaping products, I don't vape and anything. People like it and they do, but there's an additive sort of to it. Terpenes are added back in. Laboratory, it's processed into a commercial products in a way. And that's not something that, yes, you need to monitor all that, but the seed to sale that I'm concerned, the computerization and everything, I went through in business wise. I've seen computers from when they were first the Radio Shack TRS-80, when you had to, try to use them for bookkeeping purposes. And the money that's been put into hardware, software, the development, the computers and everything. And it seems like the rules are now, they're going to be forced down to make people pay more and more for this disposable computers and equipment. It should be on the state to help with the that sort of, if they want the electronic collection and the data management and all that, we shouldn't have to be paying a monthly fee to keep up with that. I feel it's, provide a program that will open the doors for reporting into the system in a manner that has open architecture. It doesn't have proprietary software by an outside Florida operation that's been given a contract, for the state of Maine. And, we have plenty of good programmers right here at the University of Maine that produce a public contract or whatever that would, save the growers some money, but monitor the activity. So thank you for your time, and good luck with the process of making it all work for everybody. See, but in particular, the medical side of it.
Thank you, Mr. Jordan. We appreciate your testimony. Any questions from the committee for Mr. Jordan? Seeing none. Thank you as always, sir, for your testimony. Very appreciated. Up next, we have Dawson Julia. He'll be followed by Hannah King and Arlie Kraus. So, Mr. Julia, when you are ready, sir.
Yes, thank you for having us today. And I'd like to say, whoops, if you can just give me a second here, we're having a little bit of feedback issue here. You just got to shut the volume off. Just shut it totally off. There we go. Okay.
Perfect.
Well, I'm here. My name is Dawson Julia. I apologize for that technical difficulties over here. And I promise we are not smoking on the job. But we do have some good comments here for LD 605. I'd like to say that I do not support it. Oh, and my name's Dawson Julia. I'm from the Maine Cannabis Coalition. Two big reasons for 605 that we don't support is it's, again, moving the plant inches to 18 inches. We feel everything should be aligned to 24 inches for the small seedlings and things like that. The other issue is this brings into the account for medical and adult use in the same building. And that's a concern for us. And it seems, it's a merger thing. The LD 525, I'd like to say that we appreciate the senator's good efforts. He's a good supporter for cannabis, but we don't again support the stores being both medical and adult use at the same time. So we don't support 525 either. In regards to LD 939, I support this bill very strongly. I feel like digital medical cards is a very good benefit during a pandemic, and it allows patients to get their access immediately. Some of these, we got to think about some of these people like pediatric patients that have been suffering from seizures and whatnot. This could be a game changer for them in a matter of hours, not days or whatever. 100% wholesale is a very, very important law that needs to be fixed. I believe probably almost the top of the list, I would say, for this year. It's affecting a lot of caregivers. And I would like to say that I've heard from some personally that have been told there's possible criminal investigations if they can't show 25% or more being sold to patients. And so this is a very concerning thing for some people that have got a different business model than others. 7 years of records, also, that's a really good thing to get rid of that law because it's just too much for the average caregiver. The third party audits is a really bad idea that I think needs to go away. Fixing the canopy fees is always a plus. The only bad thing I would say myself about LD 939 is the signage. for the commingling. And so that's, you know, again, two different programs. So it's a little concerning for us. I think I covered all the bills there. I'm hoping I didn't miss anything too important. And I apologize for taking up all the time. Well, I guess I didn't go over my time limit, so I'll just leave it there.
Perfect timing, Mr. Julia. Any questions from the committee?
I can't hear
For
anything.
Mr. Julia, while we have him.
Oh, I got it here. Yeah.
I'm gonna have to, sorry. That feedback was killing us, Dawson. I'm sorry. Seeing no questions, thank you, Dawson. We appreciate your testimony as always. Up next, we have Hannah King, followed by Arlie Kraus, and then Catherine Lewis.
Senator Lucchini, Representative Casio, and members of the VLA committee. My name is Hannah King. I'm a partner with the law firm of Drummond Woodsum. I represent Maine Organic Therapy, Remedy, and Curaleaf Maine, and I'm here today to testify neither for nor against LD 939. We fully support amending the law to allow caregivers and dispensaries to wholesale 100% of the marijuana they cultivate. However, I'm testifying neither for nor against because that support is contingent on the adoption of rules implementing seed-to-sale tracking and basic packaging and labeling standards. We would also strongly encourage that wholesale medical marijuana be subject to mandatory testing for molds, mildews, E. coli, pesticides, and heavy metals. To the extent folks have questions about why right now the current law requires a percentage to be sold directly to patients, I'm happy to answer those after my testimony. As I have said all along, we support sensible growth as long as the impact of these changes is considered by the legislature, and where necessary, such changes are accompanied by regulations to protect patient health and prevent participation by industry in the illicit market. This is relevant here because the reason the medical marijuana law did not initially require caregivers to track their marijuana, test their marijuana, or meet any health or safety packaging standards is because by law, they were vertically integrated, very small operations. They could only have 30 flowering plants, 1 employee, sell to 5 patients total who had to have one of a handful of very serious qualifying conditions, epilepsy or cancer. And these restrictions on the size and scope of caregiver operation made it unnecessary to impose other health and safety regulations. For example, testing was not necessary because of the personal relationship between the caregiver and the patient, and the fact that the caregiver had produced the marijuana they were selling directly to someone whose face they were looking at as they sold it to them. Further, the caregiver had produced the product they were selling and selling it directly to a patient. So if the patient had questions about what was in the product, the caregiver could explain to them what was in it. And then with regard, mandatory vertical integration is one of the tools, public policy tools that's used to, vertical integration is when you're required to cultivate, manufacture, and directly sell all of your products. And so because it's a closed loop system, there are fewer concerns with regard to diversion, sales to the illicit market, sales over state lines, or sales to minors. With changes that expand the scope of caregiver operations, companies can start mass producing marijuana that goes through the hands of many before it gets to a patient, increasing the risk of diversion. And they also never have to look that patient in the eye. So when the protections built into the small vertically integrated direct sale caregiver model are no longer there, other regulatory provisions, seed-to-sale tracking, mandatory testing, and labeling are required to protect public health. This is why in 2018, when the HHS committee amended the law at the caregiver's request to allow for wholesale, they also amended the law to require caregivers and dispensaries to track their product seed to sale and meet packaging and labeling requirements. These things are currently part of the pending medical marijuana regulations that Office of Marijuana Policy is trying to implement. I am particularly concerned because there are efforts to try to delay or stall these rules, which would implement these very important public health and safety policies. And so for that reason, we would encourage you to ensure that the necessary health and safety protections are in place before further expanding authorized caregiver and dispensary conduct. Thank you.
Thank you, Ms. King, for your testimony. Any questions from the committee? Okay, seeing none. Thank you again, Ms. King. We appreciate that.
My pleasure. Thank you.
Up next, we have Arlie Kraus, followed by Catherine Lewis, and then Paul McCreary. Senator Lucchini is back, so I will turn the gavel gratefully back over to him, and I will manage the clock. Thank you.
Thank you, Mr. Chair. Yeah.
There we go.
Great.
Greetings. Can you hear me?
Yep. Welcome.
Hello. Hello, committee members. Again, my name is Arlie Kraus. I'm a registered cannabis caregiver, farmer, and business owner in Warren. I'm a founding member of the Maine Craft Cannabis Association, member of Seed to Health Learning Health Alliance, and I am the chair of the Adult and Medical Use Cannabis Committee for the town of Warren. I've been a caregiver in Maine for over 10 years. Quickly, I'd like to speak to what Ms. King just spoke about in terms of testing and why testing wasn't occurring, and that there's no basis to her claims. In fact, there really were no labs to have anything tested at. As we know it, currently labs are just getting up and running for the state, and the standards for those are being built as we speak. So the medical marijuana program has been in effect here in Maine for 22 years. We are constrained in a far tighter manner than any other industry. We cannot bank legally. We are prohibited from earned income credit on our taxes, and we are still looked upon as if we are criminals from many state departments here in Maine. Meanwhile, the push for federal regulation by lobbyists for tobacco, alcohol security, substance abuse, and banking up corporations is on the horizon to take over this state's homegrown $260 million industry. How is overregulation of the medical marijuana program being justified? The data from the Office of Marijuana Policy on any statistics pointing to high crime, youth abuse, break-ins for businesses, diversion, etc., is non-existent. The only clear diversion I can find is the money that the state is paying to the cannabis public policy consultants and advocates for human potential to write and advise policy to regulate the market. Both of these consulting groups are tied to tobacco, alcohol, and other billion-dollar corporations. I ask for the data to be presented on where exactly the need for such restrictions is originating from. Based on national statistics, Maine is the lowest crime state in the nation. Considering that 8% of the population of Maine uses medical cannabis, I am certain that this plant medicine touches almost everyone in the state by at most a degree or two of separation. LD 939 is asking for patient cards to be acceptable in the digital form. This is already legal for out-of-state patients coming into Maine. We are asking for legal wholesale transactions of 100% of all harvested marijuana. We are asking for family members over 18 years of age to be eligible to be an assistant for a medical marijuana caregiver. This is common sense and practical. We are talking about farming here. Considering approximately 61% of the state is rural and 40% of the state's population resides in and around Portland, the ability in particular for rural family members to participate not only in learning a trade, but in the economics of supporting their family should be supported. Allow for registration identification cards and criminal history checks to be valid for 1 year for whatever reason. Firstly, 5 years is the standard length of time for criminal history checks to last for teachers, coaches, and substitute teachers, regardless of employment. For banking, the standard is 7 years. How can an annual background check be justified with a straight face for medical marijuana and for this check to be done every time a person gets a new job in the industry? To change the fees associated with the dimensions of growing space to be equivalent to fees for the number of plants cultivated, it's an unnecessary cost burden and still pay per plant if you select to grow by square footage.
Ms. Kraus, your time has expired, but if you can wrap it up, that would be great. Yeah.
We'll wrap it up.
Yep.
Thank you.
Okay, you can take a few more seconds if you need to finish.
Thank you. I'll just conclude here. I guess the last thing I'd like to say is that the requirement of auditing is also extremely exorbitant. I read a study in Forbes magazine. The minimal cost of an annual audit is $10,000, and that's for a very small business. Where's the rationale for an annual audit? We're not banking, trading stocks, or managing fortunes. We're a bunch of farmers, patients, scientists, and others who have built this industry to a success story of national renown. Thank you for your time, and thank you for giving me a little bit extra.
No problem. Any questions from the committee at this time? Seeing none, thank you for your testimony, Ms. Kraus.
Thank you.
Okay, next, we have Catherine Lewis, followed by Paul McCarrier. Okay, so I think I don't know if Catherine can hear us. We've got a green screen for you. If not, we can move to Paul McCarrier if you can hear us.
I can hear you.
Oh, yep. If you'd like, you can testify. We can't see you, just so you know. Oh, there you are. Yep, great.
Great. My name is Paul T. McCarrier. I operate One Mill in Belfast, which is a caregiver retail store. I'm also a cultivator and have been involved with the cannabis policy for the past 11 years, and I'm a member of the Maine Craft Cannabis Association. Today, I am here to testify in support of LD 525 and LD 939. Both of these bills, I think, are very important for the health of this industry. When we're talking about patient access, the digital certification is a very important thing. We're talking about the fact that I can go online and renew my driver's license and still have an expired driver's license, but just have a piece of paper that the state emails me. And that allows me to not only buy alcohol and tobacco, but also operate a motor vehicle. Also, when we're talking about digital certifications, it's important to remember that you can sign legal documents digitally. You can have your car insurance and other forms of insurance issued digitally. So I don't think there's any reason why we shouldn't be able to have Maine patients be able to have digital certifications to verify that they are participants in the medical marijuana program. As has been noted earlier, the proposed rules allow out-of-state patients to use digital certifications, but do not allow Maine patients to, which is unfortunate. And I think this is why we want to have a good statutory change here. When we're talking about patient access too, sometimes patient certifications run out. So being able to have access can sometimes rely on having to go to an adult use store. By having a adult use store co-locate with a medical store, you'd be able to let that happen and have a seamless access for those patients. I will also mention that we've been in support of this bill for the past 3 years. Having a store on Route 1 in Belfast leads to a lot of tourists coming in, and a lot of those tourists got the cannabis the old-fashioned way. So the state missed out on tax revenue in that regard. We are hoping that that this will not be a problem this year and that co-location will go through. Some legislative history for the idea of wholesale. When it was the idea of 75% wholesale being decided, that was literally just a number kind of pulled out in the air. I see there's a lot of veteran legislators on this committee, and back when we were having meetings in person, you know how sometimes legislation can get hammered out very quickly, and sometimes some of these details will just be almost arbitrarily decided on, as opposed to trying to figure out if that's the best public policy. It's also important to note that majority of Maine is rural. So by being able to have 100% wholesale we'll be able to continue to encourage and revitalize our rural economies. Finally, I just think it's very important to mention that the bill before us will also talk about the idea of allowing people who are 18 and over to be able to work in the cannabis field. I think that's really important. I grew up in Belfast and I live in Waldo County now. I had to move away for a while from my early 20s because there was a lack of opportunity here. I see a lot of opportunity in this industry, and I think we should be able to offer it to anybody who is over the age of 18. Thank you very much, and I'll be happy to answer any questions.
Great. Thank you, Mr. McCarrier. Any questions from the committee at this time? Seeing none, thank you for your testimony today.
Thank you.
Okay, the next group that we'll take is Alex McMahon. I don't think Catherine Lewis is here, so we'll go Alex McMahon, followed by Baker McMahon. And then I believe we have a call in from John Engler. So Mr. Alex, if you're all set to go, welcome.
Hello, Senator Lucchini, Representative Chiazzo, and the esteemed members of the Committee on Veterans and Legal Affairs. My name is Alex McMahon. I live in Lewiston, and I'm with the Healing Community Medco. I'm here today to speak in support of Bill LD 939. I'll try to keep my testimony short and sweet. So I think the increasing the 75% wholesale transfer limit to 100% is necessary. I think right now it's a burden on small businesses that no other industry really has to deal with. Certain caregivers would prefer to specialize in retail, whereas certain caregivers would prefer to specialize in cultivation. and I believe they should be allowed to do so. I also think it's important to adjust the fee structure for the 500 square foot canopy space. Right now, it's fairly skewed. So at the moment, there's caregivers that are cultivating with the 500 square feet of space using that canopy license that are paying over $8,000 in licensing fees if they want to maximize that 5,000 square feet, 500 square feet. Whereas there's also caregivers that are growing by plant count, growing in thousands of square feet. Really, it's the square footage that determines the yield. And so those caregivers that are cultivating in thousands of square feet legally, growing their 30 plants, are paying $1,200 in licensing fees. So the discrepancy there just doesn't quite make sense. So I hope the committee will consider these 2 points, raising the wholesale transfer limit to 100% and adjusting the license fee for the canopy and everything else in LD 939 I'm in support of. Thank you so much for your time.
Great, thank you, Mr. McMahon. Any questions from the committee? Seeing none, thank you for your testimony.
Thank you.
So next we'll go to Baker McMahon.
Hello.
Oh, hello, welcome.
Hi, my name is Baker McMahon, not McMahon, unfortunately. But I'm Rockland, Maine, and I'm just a med patient in the medical program. I got my med card, I think, 7-8 days after I turned 18. And the next year I had 6 plants in the ground, and I've been growing weed ever since. And I initially began studying at the University of Maine at Orono for sustainable agriculture, hoping to, once I turned 21, to enter the caregiver market medical program. And over the last 2 years, I've unfortunately seen the medical program have a lot of unfortunate laws issued into it, or tried to be included into it. Sorry, this is the first time speaking at one of these. But I'm not particularly in favor of LD 525 or 605 at all, because I just do not see any benefit of combining the medical and recreational programs in any way. I think it just leads to another step towards trying to turn them into one large program that effectively just becomes a rec program that does not support the medical program or the medical patients in any way, which I believe is what medical marijuana truly is for in the end. And I believe that LD 939 is a very great, I'm very for LD 939, especially the 100% wholesale allows cultivators to focus more on cultivating and not trying to juggle running an entire retail business. So it allows them to create better grow and create better cannabis and products overall, as well as the sorry, I got some notes taken. I think that's actually all I have to say about that. But yeah, very for LD 939, not for 525 or 605. Thank you.
Great, thank you, Mr. McMahon. Any questions from the committee at this time? Seeing none, thank you for your testimony.
Thank you.
Okay, so next up, we'll move to John Engler, and he'll be followed by Susan Meehan and Alicia Melnick. So Mr. Engler, if you can hear us, you've got the floor. Okay, I'm not hearing anything from Mr. Engler, so we will move to Alicia Melnick first, as she's in the room. Welcome, and then we'll go to Susan Meehan next. Welcome, Alicia.
Thank you so much, Senator Lucchini, Representative Chiazzo, and members of the VLA committee. My name is Alicia Melnick. I'm an attorney at Bernstein Schur and a resident of Portland, and I'm here today on behalf of the Maine Craft Cannabis Association and as an appointed member of Maine's Marijuana Advisory Commission. I'm here today primarily to speak on behalf of LD 939 and act to support Maine's medical marijuana program and ensure patient access. And just for a little bit of background, I know that many of you know this, but it's worth saying that medical cannabis gives patients working with doctors and caregivers an alternative treatment to pharmaceuticals and improves the lives of nearly 65,000 Mainers. Cannabis, and in particular medical cannabis, is now Maine's most valuable cash crop, and the industry is thriving, providing more than 7,000 direct jobs and thousands of ancillary jobs, and generating tremendous revenue to the state without assistance from the federal government, such as PPP relief, earned income tax credit, or FDIC banking privileges. And over the course of decades, and even after significant expansion, we've heard of no major public health and safety concerns or incidents related to the production or consumption of medical marijuana in Maine. And that's really important framework for what we're talking about today. I urge you to pass LD 939 and thank the sponsor for bringing it forward. It makes non-controversial, common sense improvements to the MMMP to support small businesses, support patients, and reduce liability for operators, and reflects changes in the municipal regulations and addresses other identified problems and shortcomings within the law. Briefly, annual authorization for caregiver assistance addresses long waits for caregiver employee cards and reduces the administrative burden on OMP by giving assistants an annual authorization rather than requiring reapplication and approval every time an assistant changes employers. Small businesses within our association with limited employees have been sharing their frustration with OMP for more than a year about the long waits for employee approval, many reporting 3 to 5 weeks for an assistant card to come back. These business owners, deemed essential enough in the pandemic to have been granted approval from Governor Mills to operate without interruption, have repeatedly expressed concern and frustration about the wait for these certifications. Some talk about losing great candidates to other opportunities as the weeks drag on. Others talk about the fatigue and frustration when they finally get someone approved and in the door, only to quickly realize they weren't a good fit, and they have to find some way to fill those gaps while they wait another several weeks to approve a replacement. To make frontline employees wait several weeks to be approved and receive paperwork, especially in a pandemic, is just untenable, and it's unnecessary when some of these employees have already recently worked in the industry and have been already vetted by the department. And we have been given no foundation of what the concern would be to prevent this sort of streamlining. One of our members has been waiting nearly 3 weeks for one employee card, despite direct conversation with OMP staff, and despite the fact that this employee had already been vetted and was working at another Maine cannabis business. Secondly, removing the arbitrary requirement for caregivers to sell at least 25% of their crop retail. You've heard a lot of arguments about why this common sense measure is important. One of the things that I think it's important to understand is that some municipalities actually prohibit medical cultivating caregivers from selling directly to patients, placing these folks in an incredibly difficult catch-22. Inspectors.
Your time has run out, but if you can wrap it up in a few seconds.
Sure. And just finally, that permitting caregivers to employ an adult family member who is 18 to 20 years of age. I'll just say that I was 14 when I was allowed to start selling ice cream, and I was 18 when I was allowed to start working at a restaurant that sold alcohol, which is responsible for many deaths in the state and across the country. So this is a common sense changes, and we hope that when you look at the changes to the medical program, that you look at ways to align them with other industries and related risks, and seek data, real data, when you hear vague references for health and safety protections as justifications for further burdens and costly regulations. Thank you so much for your time.
Thank you. Any questions from the committee at this time? Okay, seeing none, thank you for your testimony. Okay, we'll circle back and see if Susan Meehan is with us. Or
hello, I'm here.
There you are. Great. Welcome back.
Sorry. Well, thank you. Susan Meehan from Sweden, Maine, Oxford County. I'm also Secretary of the Maine Cannabis Coalition and a founding member of Maine Children for Cannabis Therapy. I moved to Maine in 2013 to access the program to treat my late daughter, Cindy May, who is a legacy in the program. Please Google her name. In my daughter's honor, I am a medical marijuana caregiver, currently non-cultivating, who delivers medicine to pediatric patients across Maine. I am in opposition to LD 605, 613, and 525. I support LD 939. In regard to 605 and 613, I simply don't sign blank checks. The language needs to be present before the hearing. We need a bill for this. Please sponsor a bill for this. The department needs to do better. As of midnight last night, and even as of this morning, I still cannot access LD 605. I have finally gotten language on 613 this morning. Any attempt to merge or align medical and adult use is contraindicated to patient protection and access to safe, affordable medicine, in my opinion. Future attempts to legislate this are also opposed. Going the other way, with the exception of professionals who are in the industry, like I can understand labs being able to cross mingle where labs do the same thing. So why can't they do the same thing for medical and for adult use? Medical by law, I want to clarify and make this very clear. In Title 22, Chapter 558C, subsection 2430-G, it describes the transfer of medical marijuana. Medical marijuana has only tracking of transfers of marijuana. So that would be a sale. When you make a sale to as a wholesale sale or a retail sale, that is a reported event. It is a required reported event. However, medical does not have seed to sale tracking. If you read the adult chapter, chapter 28B, title 28B, chapter 1, subsection 105, you'll see a very clear language difference that indicates that adult use has tracking from immature plant to sale. This is a very clear legislative difference. I urge you again to listen to the testimony from LD 1539, which initiated this tracking of transfers only in medical, where the legislature was told by the department that the cost would be borne by the department. However, legislatively, somehow that didn't happen. But either way, tracking is not seed to sale in medical, contrary to some people's beliefs. In regard to LD 939, I do support this bill. Overall, it supports the family business and how things happen. When an 18-year-old comes of age in a family, they're often asked to help with the family business, or they might want to get into the same business as their parents. I also agree with sales. What does it matter whether they're wholesale or retail? And not all of us are cut out for retail. It can get very dangerous. We've had caregivers who have thought they were going to meet a legitimate patient robbed at gunpoint and knocked up in the head with a gun. This is important. If you don't have the means to have a retail store, why am I forced to retail products? That doesn't necessarily apply to me, but in general. In regard to digital imaging, you've heard it. I mean, it's the 21st century, come on. I also want to talk about the way that it happens in my particular business. I get an email from the
Ms.
doctor.
Meehan, your time has expired, but if you can wrap it up, take in 15 seconds, whichever. Yeah.
Basically dealing with pediatrics, I have communication from a doctor and the parent before I ever see the patient to obtain a physical card so that I know what they need before I meet with them. So in context, that's considered accepting a digital card. But when I see them physically, obviously I'm going to check the actual card. I need to see a birth certificate for a pediatric patient, and I need to see a parent's ID for a pediatric patient. So I just urge you to pass this. I think it's a good piece of legislation, except for the canopy still being too small. Larger canopies mean healthier plants. That's all I have. Sorry.
That's okay. Thank you. That's all right. Thank you, Ms. Meehan. Any questions from the committee? Representative Corey.
Thank you, Mr. Chair. My one sort of big concern with that bill is still the idea that we're talking about putting in advertising both medical and rec, and I don't want to confuse people about those two programs. Are you amenable to removing that from that bill?
Yes, absolutely. I truly think that the crossover should only be within the industry, such as medical, such as labs that are processing.
Yeah.
Processing labs ought to be able to process for both, in my opinion. However, I don't believe that the programs should be any further aligned and merged than they are currently.
Thank you.
Thank you.
Great. Any other questions from the committee? Seeing none, thank you for your testimony, Ms. Meehan.
Thank you. Have a great day.
You too. I'll just circle back quickly to Mr. Engler and see if he's able to hop on. If not, we will move to Brett Messer, who doesn't look like is in the room, followed by Amber Patterson. And after Amber, we will go to Thomas Portlock.
Hello, I don't know if I'm
Yep.
live or not. I can't hear anybody.
Is this Amber?
Yes, this is
Yes.
Amber Patterson.
We can hear you. We can't see you, but we can hear you, which is fine if you're.
Okay,
good with that.
perfect. I apologize. I'm in Kennebec County. I'm in a rural county out here. I'm in Fayette, which is one of the inhibiting reasons for seed to sale tracking in itself, is that the majority of the time you guys are not going to be able to have me streaming. You know, it's one of those issues I think that all of us Mainers deal with, is not being able to be connected full time in live to actually do these things. That being said, in support of LD 939, I believe that we need to allow for wholesaling and allowing the rural farmers to be operating. I know it's one of the things that is most difficult for my personal business, is juggling my retail side of it. I only do 25% in retail, and I have to do all of that out of my home. Unfortunately, it makes it so that my home is not very personable. I never get to fully escape work, and I think that that's a huge issue for us across the board. I would like to say, I know I didn't sign up to speak about 525 or 605, but I do believe that we should not be aligning these programs. I know that Eric Gunderson, when he spoke earlier, he specifically stated that all of these requirements were meant to align the program. And he did say that he misspoke and that he meant implementing. But I think it's the first time we've heard any truth from him. He's trying to legitimately align our programs. He wants to be able to close it out. Every step of every day when we're looking at these new proposals from the Office of Marijuana Policy, there are ways to squeeze out small farmers like myself. And I just want to reiterate that we shouldn't have to fight for our rights to work every day. I should be able to be in my garden and not constantly trying to see if my Zoom meeting is calling my name yet. Not that I'm not grateful for you guys taking the time to listen to me, but it's just one of those burdens on small businesses. I don't have assistants. I hand water all of my own plants. When you guys increase our canopy size, I'll be hand watering even more of an area. So, it's one of the things that us as small farmers, we need to have some of the allowances so that we don't get completely eliminated in this program. So that's all I really have to say.
Okay. Thank you, Ms. Patterson. Any questions from the committee at this time? Seeing none, thank you.
Thank you. Have a great day.
You too.
Thank you again. Bye-bye.
Next up, we have Thomas Portlock, and Thomas will be followed by Asher Putterman and Robert Scott.
Hello again. How you all doing?
Welcome.
Thank you. Again, my name is Thomas Portlock. I'm caregiver and co-founder of Emerald Organics in Buxton, Maine. I think Arlie Krause covered most of what I wanted to say, particularly in regards to Hannah King's false claims. So thanks for that, Arlie. I'll just say a few points. I stand in favor of LD 939. This bill is exactly what the medical cannabis industry is looking for. Eliminating the unbelievably obtrusive 25% retail law will allow many businesses to scale up and stop wasting time trying to balance a wholesale and retail business model. We'll be finally free to focus on a more streamlined and efficient business plan that suits our particular goals in this industry. Forcing caregivers to find retail patients for 25% of their sales effectively reduces their ability to increase their wholesale volume and actually encourages caregivers to turn to the black market to offset their wholesale numbers to match the bottlenecking that occurs with 25% retail. It has the opposite effect that Hannah King claims with allowing 100% wholesale to occur. Allowing medical patients to possess digital copies of medical cards, it's a common sense change that will ease their access to medicine. Adding an appropriate fee for canopy cultivation is a must, and while state limitations on production are not reasonable in my view, refining the current language to reflect reality in terms of cultivation strategy is certainly a step in the right direction. Then in terms of bills 605 and 613, what business are bills without text having a public hearing? I think it's completely unreasonable and subversive to ask the public to weigh in on bills they haven't even seen. So I'm opposed to them on principle. And then I'm opposed to LD 525. In my review, it's another attempt by OMP to move as much of the medical program towards recreational as possible. Medical and recreational is two different markets and should remain separate. This is unfortunate, but OMP and the state has created an issue by creating a recreational market with frankly foul taxes and regulations. And instead of reviewing and improving the recreational legislation, there's concerted effort to try to move recreational to move medical to recreational. I just think that's not the right move. And then to finish up, just additionally in general, I'd like to add that the black market is still a big part of the Maine cannabis industry. And the only way to capture more of the market and induct them into the taxpayer base is to create a favorable system that incentivizes the creation of legal business. I guess that the black market is about 5 to 10 times bigger than the medical market. So instead of eliminating small businesses through additional regulation and decreasing the number of taxpayers, the state should be making the process of legal business operation as easy as possible. There's a lot of revenue being left on the table from the perspective of the state. And I don't think that any amount of law enforcement activity will ever make a dent in the free market or the black market, as we see in states like California, where after years of recreational operation, 2 out of every $3 spent on cannabis is still being spent on the black market. This is due to terrible policy decisions that have forced many former legal businesses to close or go back to the black market. I see the same boilerplate legislation being presented by lobbyists and lawyers through OMP that created this disaster in other states. So I implore you all to take this into consideration when voting on policy decisions moving forward. That's it. I went a little over my time, but
thank you.
Thank you.
Thank you, Mr.
Thanks very much.
Any questions from committee members at this time? Seeing none, thank you for your testimony today.
Thanks so much, everyone. Appreciate you.
Great. Next up, we have Asher Putterman. Asher will be followed by, I believe, Robert Scott and Derek Short and Mike Wilson. So welcome, Mr. Putterman.
Hi, sorry, having to run back and forth. My farm's getting hammered by some wind right now. We got a lot of greenhouses.
It's crazy out there.
I'm trying to keep up with everybody's testimony, and I have some notes to comment on it. My name is Asher Putterman. I'm a patient and caregiver in Warren, Maine. I'm here to testify in support of LD 939. This bill offers a lot of common sense changes needed for the smooth functioning of these businesses. This removes the mandatory 25% retail sales required by the department, while the department has done and is still doing everything in their power to limit our abilities to sell retail. We are a farm and wish we could just farm, but as our business has grown, we're being forced into having to take on retail ventures that are beyond what we normally would choose for our business in order to stay compliant with a ridiculous law. This was originally put in as a stipulation to protect the medical market from collapsing, causing patients to be short on their meds. What we've seen is the opposite. The medical market is thriving. This bill also fixes the problem in the fee structure for growing by canopy square foot instead of by plant count. This was caused by a technicality in the fee structure that made the canopy square foot basically useless, as it is still tied down and forced into an expensive plant count scenario and still limited by plant count. Smaller plants are easier to grow and stay healthier as they have stronger immune systems and less exposure to disease. This plant count change to square foot was meant to address this, but as it has been tied to a plant count fee structure, it has yet to provide this in practice. This bill also relaxes some of the duplicative and burdensome record keeping that gets put on us repeatedly every session, it seems. But never seems to be used by the department to gather any kind of useful data or do anything with. Just adds a lot of work for us. I wanted to respond to Kate's earlier testimony from the Maine Municipal Association, and it's my opinion that 25% more sales will not dramatically change the already existing caregiver cultivation facilities that have been legally licensed and in existence many for over a decade. At least it would not change ours. What it is causing, and it is causing this for us, is all of us who wish to just farm are now having to open stores in these communities to retail the required 25%. In regards to the tiering that Representative Corey brought up, my concern would only be that in their recent rulemaking offered by OMP, There was an extremely small tier and a very large tier, and nothing that reflected reasonable rules for the scale and size of our particular business. The small scale was too small for us to make a living from, and the large scale was overly burdensome for our business to survive. I would also point out, in response to Mr. Gunderson's comments about a lack of data, that a lack of data is in itself data. If there were hospitalizations from tainted products or criminal issues, we would have that data, as hospitals and police both track this data. So to then make us purchase a costly system to track and monitor everything we do, more like OMP, is just creating more problems. Why can't we track our sales the same as any other business? Why can't the department use their excess amount of funds to develop an internal system that doesn't pass on these ridiculous costs to us and just allow us to report our sales? It seems to just simply enrich out-of-state big business. And Mr. Gunderson even said that this was in statute, but the statute actually says that OMP should develop and implement a statewide portal, not just bring in an out-of-state business bidding for the work they should be doing internally with the money that they have to do this.
Thank you, Mr. Putterman. Any questions from the committee at this point in time? Seeing none, thank you for your testimony.
Thank you all for your time.
Yep. Okay, next up, we have Mike Wilson. Not seeing Robert, Scott, or Derek Short in the list. So Mr. Wilson, we're ready when you are. Yeah, welcome.
Hey, how's it going? Okay, my name is Mike Wilson. I live in Portland, Maine. I'm a caregiver and a business owner of Maincraft Cannabis Incorporated. I'm here today to speak very strongly in support of 939. And I did want to, first of all, just thank Bill Pluker. I think it was really, I don't know if I think that's how you pronounce his name. I think it was really cool to hear somebody who's a rep actually understand a lot of what we're going through. And I'm not saying that you guys don't understand, but to hear it from somebody was really cool because, you know, my background is, you know, I've been in engineering my whole life. My wife and I got into this industry 3 years ago, and I didn't understand what it was like to be a farmer or involved in agriculture. And it's a very risky endeavor just because you're dealing with plants and things go wrong. And I do think that there is a success story of what's going on in Maine, and we just need to keep that going. I think that the 100% wholesale really helps everybody. I think that the 75% is really what enabled us to continue being in business. We were having a hard time at that point, and much like I think his name was Donald was talking about, the ability to wholesale was incredibly important to us. So moving that to 100% is great. I think that requiring us to have 25% direct as our business grows is actually difficult because we don't necessarily want to have people to our house, and you know, we don't have a delivery service, and meeting patients, it's somewhat burdensome. I think it should be a choice that we all have to make independently. So I'm very much in support of that. Also, the caregiver assistance requirement to register with every caregiver, I think, is very difficult for a lot of people, especially trimmers. It's tough for us. We basically have to have all of our employees also be our trimmers instead of being able to hire somebody that's a trimmer that goes to multiple caregivers unless they register with every single caregiver. So I'm in support of everything in 939, to be clear. The 605 and 613, I'm actually kind of confused by this. I think I mentioned earlier that I'm a little bit new to this, and I did look last night and then I checked again this morning, and I couldn't find any text for it. I'm not sure when or how it was sent out, and I just checked again during this meeting, and this is supposed to be public comment, and I don't even understand what I'm supposed to be commenting on. I'd like the ability to comment on anything related to this stuff. So I really don't understand how this would be called public comment on that. So I don't know if I didn't find it, if I looked in the wrong place or whatever. That's it for me. I'm done.
Great, thank you, Mr. Wilson.
Thank you.
One thing you may want to do is join the interested parties email list. Like when we
Okay.
get the language late from sponsors, then we try to send it out as soon as we can on that. But it is difficult to find that information. I agree.
How do I register for that?
We can get you some email our clerk if you can. our committee
Okay.
clerk, and we can go from there.
Thank you.
Yeah, any questions from the committee? Seeing none, thank you, Mr. Wilson. So at this point, we'll see if there's anyone else who wishes to testify in the attendees list who hasn't had an opportunity to testify already on this group. I know we had some with technical issues, just doing a quick run through. Okay, not seeing any. Okay, last call. So we've got no more to testify. So with that, I'll close the public hearing on LDs 939, 605, 613, and 525. Representative Corey.
Thank you, Mr. Speaker. And I think a lot of people have brought this to our attention today with the concept drafts and, not being able to access the information, a huge part of it. And we've been learning, through the process that kind of in those committee material sections that's there. But of course, they would have to know who's presenting that concept draft, whether it's something coming from OMP or the bill's sponsor or whoever it is, to be able to sort out who put that in there. I think this speaks to a larger issue. And, I've spoken with a lot of people that follow this, and it's just not in our committee. And I think it's sort of that glaring problem with concept drafts now that, maybe instead of getting rid of the ability to do concept drafts, I know this is a much larger discussion, outside of our committee, maybe there should be a deadline on when there's a concept draft, how many days in advance actual language has to be associated with that concept draft. I still find it really frustrating that when I go out and I hop onto the legislature's website because I have a constituent that wants me to follow a bill, and I plug in the LD number, and when I go to the bill draft, rather than showing, do you know what I mean, the new language that's essentially what the bill is in, it still has that base concept draft language in there. And then I would have to really hunt around in the testimony or contact the bill sponsor or contact somebody on the committee to get that material. So I know how frustrating, this is as a legislator, but I imagine it's got to be 10 times more frustrating as a person in the community. So I just wanted to offer that up and a couple of thoughts about that. And, thank you for letting me waste 2 minutes of your time this afternoon as I expressed my grievances with concept drafts. So
This is the time to do it. No, I'm with you. I'm not a big fan, but this session seems to have a lot more. I think just doing everything remotely, it seems to have created a lot more of these. I put one in too, and I can't believe it. Yeah, so great. So I think that is it. Is that right, Chairman Chiazzo? I believe that's all we've got on the schedule for today.
I think that's all on the docket, Mr. Chair, and we can get into housekeeping stuff before we conclude.
Yeah, I think we'll we'll just have a session, I guess, the next couple of days, and then we come back on Friday, I believe. Are we all set, Sam, from your end with bills? Good.
Yeah, I think we have done everything that was on the schedule today.
Okay, awesome. Great. Well, thanks everybody for being here today, and we'll see you all in person tomorrow. So with that, we'll adjourn the meeting.